My name is Larissa Jane Houston, and I am this year's conference organizer and coordinator. Currently, I hold a position as a project researcher at the ClimLaw Graz, as well as a doctoral candidate at the University of Graz in the Institute of Public Law and Political Science. Additionally, I hold other positions within various organizations dealing with environmental law and climate change law at large. Today and for the rest of this week, I will be your host and moderator, along with my colleague, Ruppel, who is a participant in this year's workshop and co-organizer dealing specifically with our Latin American colleagues. Now, without further ado, let us begin the ClimLaw Graz second annual PhD workshop on climate law and litigation. To provide you with a brief agenda of today's proceedings, kindly find below the structure of events. The agenda will also be posted in the chat for you to review at any stage in this webinar. Before we go further with the webinar information and housekeeping, I would like to hand over to Professor Oliver Ruppel, the Director of ClimLaw Graz and the Development of Rule of Law Program at the University of Stellenbosch, who will commence our proceedings with a few opening remarks. Over to you.
Thank you very much, Larissa Jane Houston, the organizer of our second annual PhD workshop on climate law and climate litigation. It is a great pleasure to welcome everyone online for our workshop, for our 5-day workshop, which is the second of its nature, and that of course makes us proud at the Center for Climate Law at the University of Graz in Austria, and also together with our partners that are here online with us, because ClimLaw Graz is only one of the organizers of this event. It is conducted together with the United Nations Environment Program, and I have the special privilege to welcome Professor Patricia Kameri-Mbote, who is a director at the Law Division at the United Nations Environment Program in Nairobi, Kenya, online with us. And she's also the presiding chairperson of the Association of Environmental Law Lecturers in African Universities, and one of the founders of this organization. And secondly, our co-organizer, the German Environment Agency, Umweltbundesamt from Germany, here today represented by Dr. Harald Ginzky. I understand that his colleague, Dr. Nadja Salzborn, could not be with us here today, so he's taking over the responsibility to represent the German Environment Agency. And then, of course, the Development and Rule of Law Program at Stellenbosch University, which I'm, so to say, representing in a dual manner, together with my hat from ClimLaw Graz from the Global North. I'm privileged to also represent the Development and Rule of Law Program from Stellenbosch University from the Global South. And this is already a reflection of what we are planning to do, namely to span an arc between the Global North and the Global South, between all continents on the issue of climate law and litigation. Before I say a few words about this, I would also like to cordially welcome all the distinguished speakers, the professors from all over the world, and particularly the PhD candidates from all over the world. And I understand from the program that we have quite a number of PhD candidates that have already presented at the first annual PhD workshop in 2022 and have returned. So apparently it was a success for them, but we are also delighted to welcome new ones, PhD candidates from various continents sharing their research with us. And we find this a very, very valuable exercise, an exercise that was initiated in partnership with the UN Environment Program and UBA, where we did not anticipate so much interest in this program and project. And with the support of Larissa Jane Houston, we have found an organizer who is really hands-on, and who is already in the process of finalizing the publication of the first annual PhD workshop from last year, and she will share more on the intention to have another publication coming out of this program and PhD workshop of this year, so that this is hopefully becoming an annual happening, attracting more and more PhD students to share and to give us their inputs of their research. And yeah, so in this regard, there's not much I would like to add, except having a short glimpse at the name of the different sessions, because of course all of you know climate law and climate litigation is emerging rapidly with a different pace, of course, on different continents, but at national level and international level. But we do recognize also from the urgency of the matter, climate change and international law in times of global crisis. This is the name of the first session, and I think it is important to acknowledge that we do live in a global crisis, and the law plays an eminent role in order to get a grip on this. If we go to the second session, national and international climate litigation, individual states, companies, and nature, a lot of litigation efforts are happening on this front, both from an individual states, companies perspective, but more and more we find cases dealing with nature, dealing with rivers, putting challenges, legal challenges before us in terms of procedural access, standing, causation, and so on, which we will discuss, of course, in many of the sessions here today. And next, session 3, loss and damage, attribution, causation, compensation, liability, bringing climate damages to the fore in a context where all of a sudden climate change is being viewed through a lens of justice, of intergenerational justice, interspecies justice, and also looking back, climate change as a result of industrial activities, climate change in the context of slavery, apartheid, racism, gender inequalities. These are issues that both at, of course, international, but also domestic level gain much attention, and especially in view of the fact that ClimLaw, Graz, and Stellenbosch are investigating these issues from both the global south, but also global north perspective. That's where the collision is happening. And I think in future, we will find more and more case law also dealing with the responsibilities of companies and also perhaps of states in the context of intergenerational equity and damages. I don't want to preempt any of the sessions. The last session dealing with trade, which is of course of particular interest to me, as this subject is gaining a lot of traction. The World Trade Organization is becoming greener. The attempts to utilize the functioning court structures, or maybe not so well functioning court structures at the moment at the WTO, could become a game changer. And I know the Director General of the WTO has high ambitions in this regard to make trade more sustainable. We live in a time of Russian aggression, a time where food security, especially from an African perspective, is becoming critical. In that sense, climate change and international trade shortcomings in the past will have to be addressed in order to make trade more equitable for the future. And that is something which will be part and parcel of session 4, leading to session 5, climate change and just transitions, legal considerations of carbon neutrality. This is where the music plays. I think we all know that the climate is a universal phenomenon. We cannot we cannot act in isolation, but we need to find a way of just transition, and that we need to find fast in order to become carbon neutral. And that is a global requirement. In that regard, the last session will also be instrumental in making an assessment that can perhaps inform us on the way forward. I don't think that I want to mention more than that, apart from the fact that it makes us proud at ClimLaw Graz that the interest is high, that PhD students are more and more emerging in these fields of the law, and the discussion and the need for discussion is there, and we want to feed the discussion. We want to contribute to the legal discourse in order to make this important field of the law, climate law and litigation, more conversant and more prominent and more reactive to the needs of our global crisis. With that, I want to thank Larissa Jane Houston once again for her efforts in putting this together. And I would like to hand over to my friend, colleague, and partner, Professor Patricia Kameri-Mbote from the United Nations Environment Programme. Thank you.
Thank you very much, Oliver. And it gives me great pleasure to be at ClimLaw Graz for the second year. And also from my background as an academic, I am very excited to see the growth in interest in this work. Probably I should correct that I am now not the one convening the Association of Environmental Law Lecturers from African Universities. Professor Colin Zodote took over from me when I joined UNEP. I would like to, in my opening remarks, to highlight the importance of climate law research and speak about our collaboration in this area. Distinguished colleagues, distinguished participants, today our planet is dealing with an interconnected crisis of climate change, biodiversity loss, and pollution. The UN Secretary General has termed the current state of climate as a code red for humanity. Increased concentrations of greenhouse gas emissions are wreaking havoc across the world and threatening lives, economies, health, and food, as Oliver just outlined. Time, as we keep on being told, is running out. People around the world are in the fight for their lives, and sadly, if we do not heed the call of science, it appears that we may lose. We have used the equivalent of 1.6 Earths to maintain our current way of life, and ecosystems cannot keep up with our demands. There is extreme loss of life, with millions of plants and animals threatened with extinction. Global temperatures keep rising. The air we breathe, the water we drink, and lands we live on are increasingly being polluted. Our planet is fast approaching tipping points that will make the negative impact on nature irreversible. These problems are transboundary, not national. We know that the increase of greenhouse gas emissions has led to drastic climate change events around the globe, like sea level rise and global warming. We see ecosystems and even countries gradually disappearing. We find that pollutants in our bodies and in our food are negatively impacting the health of individuals and communities. We need transboundary answers, international cooperation, and a whole of society approach. Climate law research and collaboration is of central importance in addressing some of the challenges that we are facing. Climate laws, which include legislation and case law, need to be collaboratively researched and developed. This year, as we prepare to publish UNEP's Global Climate Litigation Report 2023, we have noted an increasing role that climate change litigation is playing in the domain of climate law and policy. This has been demonstrated by an increasing number of climate change litigation cases. The report finds a significant increase in the number of climate litigation cases from about 884 cases in 2017 to 1,550 in 2020 to 2,180 cases as at December 2022. Claimants are asserting that failure of countries to implement climate laws and inadequacies in action on mitigation and adaptation violates the rights to life, health, food, water, liberty, family life, and health environment, which the report refers to as climate rights. Successful climate change litigation cases like Agenda Foundation versus the State of Netherlands have further motivated other litigants to challenge ineffective climate laws, seek strengthening of climate laws, and call for improved action on mitigation and adaptation. UNEP supports countries to strengthen their climate laws in close cooperation with the multilateral environmental agreements aimed at achieving the 2030 agenda, including the United Nations Framework Convention on Climate Change. UNEP works with government, civil society, and businesses in areas including integrating climate change into national laws, policies, and development strategies. UNEP's law division, through the 5th Montevideo Environmental Law Program, supports countries to strengthen their climate laws in promoting the progressive development of the environmental rule of law. The law division also, through its Ozone Action branch, contributes to bridging the gap between science and policy by supporting countries to eliminate ozone-depleting substances and reduce use of chlorofluorocarbons and hydrochlorofluorocarbons. UNEP's Faith for Earth initiatives also has a mission of encouraging, empowering, and engaging with faith-based organizations as partners at all levels towards achieving the Sustainable Development Goals. A recent webinar on faith institutions and UNEP's joint appeal for climate responsible finance, a moral imperative towards children, called for increased attention on the potential of responsible finance towards tackling climate change. UNEP also welcomes partnerships with various stakeholders, including professors, lecturers, scientists, and private sector actors, as we work towards strengthening science policy society interfaces towards addressing the most pressing challenges, including climate change. Through Infomare, UNEP provides free courses on environmental law, including on climate change. For example, Infomare has an introductory course on climate rights litigation. Capacity building for lawyers, judges, and other key stakeholders is important to support action through climate litigation. UNEP and partners have for decades promoted capacity building for judges. As environmental matters can be complex and technical in nature, countries should maximize the potential for specialized training for judges on environmental matters and prioritize strengthening of courts and tribunals for environmental cases, including climate cases. The law division is deeply committed to advancing the work of environmental law, governance, and related policy issues across the globe. That is why our partnership with the Global Judicial Institute on the Environment to build judicial capacity around the world is so important to us. UNEP's work on climate change cuts across a number of initiatives, partnerships, and other key entities, which include the Climate and Clean Air Coalition and the Climate Technology Center and Network. UNEP also works with various partners, including the organizers of this workshop. We are very proud participants in ClimLaw Graz. We welcome the discussions at this workshop and encourage further research and collaboration on climate law and climate litigation. We hope that through these interactions, we can collectively contribute to a better future where the climate is stabilized, where rights are upheld, and where the environmental rule of law is promoted. I wish you all fruitful deliberations. Thank you.
Thank you very much, Patricia, Professor Kameri-Mbote. No one could have said it better. No one could have officiated it better. And as you, having worked in this field for so many years, both as an academic, but now at the brim of politics and diplomacy, which is so important in order to give the ultimate attention to this field of the law. And it is a great honor for us to have you with us, and we count on your continued support, both intellectually and also as a representative of this important program of the United Nations Environment Program. So we come to our next partner, and it's also a great pleasure to again be here with the German Environment Agency, with whom we have cooperated also over the years in various international projects, in publications, in conferencing, in policy advice, in legislative drafting advice, and so on. It is a great pleasure, as always, to have Dr. Harald Ginzky, who in the meantime is, so to say, already a part of our constant advisory body, but also representing the United Nations and the German Environment Program in the context of climate. But we do, of course, acknowledge that he is an expert, especially on soil, and that is a new field of climate research that we are also jointly engaging on. Dr. Harald Ginzky, pleasure to have you with us. The floor is yours.
Many thanks, Oliver. I start a bit officially. Dear Professor Oliver Ruppel, dear Patricia, Professor Patricia Mbote, hello, my dear friend, dear Miss Larissa Jane Houston, dear presenters, dear participants to the second annual PhD workshop on climate law and litigation. Good morning, good afternoon, good evening to all of you around the globe. It is, of course, my distinct pleasure to say a few words on behalf of the German Environment Agency at the beginning of this fascinating workshop, which brings together so many PhD students and academics from all over the world in order to discuss this important topic of climate law and climate litigation. My name is Harald Ginzky. I'm an environmental lawyer already now for more than 30 years, which is a bit scary, but it is the case. I work for the German Environment Agency, and my core topics are soil and water law, governance of the oceans, climate engineering, deep seabed mining, and transformation science now for a few years. The German Environment Agency is something special, as we work in between science and policy. The entity with its 1,800 employees, which are mostly academics, has mainly two tasks. First, we are to provide science-based policy advice to our ministries. And we do that on an interdisciplinary and sometimes even on a transdisciplinary manner, meaning by the involvement of stakeholders and concerned people. Thus, in essence, we collect all available scientific information and transform this information into an advice for policymakers. We could do so as we have most, if not all, scientific disciplines represented in our agency, which is really great. The transformation of scientific information into policy advice may sound somewhat easy, but in fact, it is a very demanding and it is in itself a scientific process. I would like to emphasize that. The second task of our agency is a bit more modest, you may say, but equally important. We are in charge of actively informing the general public on all topics of environmental protection and sustainability. So if you may have a look at our website, you will find information to mainly all environmental and sustainability challenges, of course, both in German and in English. Before I would like to make a few remarks to the workshop, I would like first to congratulate Oliver Ruppel and his team for organizing this important, timely, and forward-looking workshop. This is excellent and provides such an interesting and enriching platform for all speakers and participants. And so just to emphasize it again, many thanks for your organization. This is really helpful and instrumental. Seeing the program, four core topics of climate law could be identified. Climate litigation, role of specific actors, women and indigenous people, human rights perspective, including loss and damages, and just transformation and economic aspects such as international trade law. In my view, these topics are really well selected. Climate litigation is that important, in particular to prompt policymakers to do their job. This is really crucial. And secondly, to ensure liability for insufficient climate-related behavior, intended or unintended. Thus, there will be certainly more to come with regard to climate litigation. However, the latest three topics seem to be even more important for the following reasons. Climate mitigation and adaptation requires above all implementation. This must be undertaken very, very soon. And in that regard, an actor-related research is very crucial. So women and indigenous people have a very essential role to play in this context. And we need to talk about those people who will be affected by the effects of the changing climate, which will suffer due to losses and damages. And in this context, the human rights perspective becomes continuously more relevant. And last but not least, this topic, just transformation. In the scientific work of my agency on the consequences of the corona pandemic and the Ukraine crisis on sustainability policy, we clearly come up with the result that sustainability and climate neutrality can only be achieved if the required transformation addresses both. A transformation in ecological and in social terms. In other words, without a transformation to more social justice, the transformation in ecological terms will most probably fail. Actually, this is nothing particularly new. As inter alia, the Sustainable Development Goals exactly carry this spirit of a social ecological transformation, and also the reports of the Club of Rome have underlined these requirements, particularly in the report of last year. Just transformation needs to materialize within societies at national level, but also with regard to international cooperation. Therefore, the emphasis in the program of this year's PhD workshop on international trade is also very forward-looking. Before I end, I would like to express two wishes for the third and perhaps the fourth PhD workshop. I would hope that two additional aspects could be addressed by future webinars. Give me a minute. First, my agency has initiated a debate. First, my agency has initiated a debate, mainly at national level, whether a new form, a new type of law with new characteristics is required. We have called this new form of law transformative law. Humanity is under extreme time pressure. We as humans need to rebuild our societies within a decade, which affects most societal sectors, such as energy sector, including electricity, as well as heating and cooling of buildings, traffic, or food supply. Our questions are therefore, how could we initiate how could we initiate innovations and direct these innovations to more sustainability by continuous evaluation and adaptation? And how could law initiate the required corporations of those who are willing and capable to implement measures leading to more sustainability? So this is the question with regard to transformative law. I'm very sure that these questions are not only relevant in Germany, but also within all societies around the globe and for the international cooperation. Therefore, I would hope that we could address this topic in one of the upcoming PhD students by ClimLaw. My second recommendation would be to have a closer look at the developments and needs in China and India, the two countries with the highest number of people. The level of complexity of existing challenges in these countries are first very demanding and second, scaring and motivating at the same time. Having a closer look would also provide very interesting insights for the work in other parts of the world. With that, I would like to conclude. I wish you interesting presentations, fruitful discussions, and actually an atmosphere of optimism. Optimism is needed and feels good. We keep the momentum. Many thanks, and a lot of success for the workshop. Many thanks.
Many thanks, Harald. This is a very encouraging introductory note, and we also take very positive note of the two suggestions that you have made, which I find extremely important. The one on transformative law, we've been in exchange over that one already, and I think it's a point that for our cooperation with UNEP, we should also take this further. As the law, we live in a digital age now, is becoming different than it used to be in the past. It's becoming more proactive. It's less reactive, especially in the context of innovation. And we do take note of this. The second aspect is, of course, also key, not only in light of the fact of the, again, Russian aggression, as geopolitics is shaping a new reality around the world where China and India, but also, humbly speaking, South Africa and BRICS and Brazil may play another role in that regard. So I think a closer look at the developments in these countries and the needs, like you say, is a mandate that we should take very serious. With that, I think that we have come to a point where I have to hand over to the most important person in this workshop, that is the organizer, and Larissa Jane Houston. Again, our words of thanks to all the efforts that you have taken in shaping a new network of PhD students, a new network of climate lawyers, climate litigants of the future, in bringing us together around the virtual table of this PhD workshop for the second time, and certainly not for the last time. I think it would be no one more capable to introduce the core of this workshop, to give some housekeeping advice, and also introduce our center and perhaps make it known to our audience here today, so that perhaps we can grow cooperation. In the end, we will only get a grips on the most important issues of our time if we foster cooperation on a new level. With that, I would like to thank once again all the partners present here today, and hand over to Larissa Jane Houston for the introduction to the workshop and so on. Thank you.
Thank you to Professor Ruppel, Professor Kameri-Mbote, and Dr. Ginzky for your opening takes on this year's workshop. I believe with those opening statements, we can clearly see what the goals of this workshop are and why the partners that we have for this workshop are so crucial for the development of climate law and climate litigation at large. It is an honor to have you as part of our webinar and to join UNEP, ASSELLAU, UBA, and DROP in promoting research and exchange in the field of climate law. In the next 20 minutes or so, I have the honor of introducing you to ClimLaw Graz and to the PhD workshop at large. ClimLaw Graz is a research center for climate law at the Faculty of Law of the University of Graz, established in 2020. We are in a continuous process of research, development, and expansion. ClimLaw Graz is part of the interdisciplinary field of excellence, Climate Change Graz, of the University of Graz, an association of researchers at the University of Graz who jointly research and share their knowledge on climate change and sustainability. We are a group of international lawyers and interdisciplinary doctoral and postdoctoral researchers. ClimLaw is a multilingual and multicultural environment with staff from various continents. Our working languages include German, English, French, Spanish, and Portuguese. Who are we? We are made up of the core team, consisting of doctoral candidates and postdoc candidates and researchers. We also consult with a scientific advisory board and a stakeholder board, as well as multiple partners and international cooperations to progress our research in the field of climate law. The Research Centre's task is to critically observe and legally and politically analyze current developments in climate law from international, regional, and national perspectives, and to carry out research projects with a focus on climate and environmental law, together with national and international partners from science, policy, diplomacy, and practice. In future, it will also serve as a networking platform. Our research areas include, but are not limited to, climate protection law, environmental and energy law, ecological change, climate lawsuits, public participation, interdisciplinary research on climate protection, world trade law, climate change and human rights, international humanitarian law. Due to its close links with climate science, climate economics, climate ethics, and so forth, and its intensive cooperation with stakeholders, ClimLaw Graz is transdisciplinary and acts as a competent partner for scientific reports, expert information, and legal advice. It is within our goals at ClimLaw Graz to provide a space to engage and develop research in the field of climate law and litigation. As such, we began the ClimLaw Graz annual PhD workshop on climate law and litigation. Each year, a number of academic institutions host PhD workshops across various fields with the aim of assisting PhD students, as well as fellow researchers and academics in presenting research and sharing ideas or engaging with fellow academics on topics of interest. It is within this context that this PhD workshop was envisioned. Often, there are a number of PhD workshops hosted which specialize in environmental law on a broad basis. These workshops have been extremely useful in addressing environmental issues. However, they fail to provide in-depth analysis and discussion on more particular aspects of environmental law, such as climate law. Therefore, with this in mind, the ClimLaw Graz PhD workshop was introduced to address the gap in climate law research by providing a workshop directly tailored to climate law and its various nuances. With this annual workshop, ClimLaw Graz seeks to provide academics and researchers alike a platform for engaged discussion and insight. As an international workshop, there are no limits to region or topic. As such, each year, the workshop will cover different or expanding elements of climate law, while also seeking to, comparatively, address developments in climate litigation and rule of law. Additionally, the workshop functions with the structures of a newly established seminar at the University of Graz, which is the Comparative Law and Litigation Seminar. Now on to some housekeeping. The working language of the workshop is English, and as such, all content, comments, and questions will be addressed in English. Please ensure your microphone is muted at all times unless you are speaking. This will be monitored by us at the ClimLaw team. We encourage you to engage with us throughout the workshop, and as such, when you have any questions for our speakers, please be sure to utilize the chat function located on your panel at the bottom of the screen. Or you may ask a question directly during the question and answer session by simply raising your hand and unmuting yourself accordingly. Questions asked in the chat should be directed at myself or to everyone so that I may read them out. We will answer chat questions first before opening the floor to open questions. The more everyone engages, the better the question and answer session will be, and so we encourage you to actively take part in this workshop. It should be noted that the workshop will be recorded to ensure that the research and expertise provided by the presenters is shared outside of this workshop. As such, all final recordings will be posted on our YouTube account titled Research Center for Climate Law. Doctoral candidate presentations are based on ongoing research by each of the candidates prior to their final thesis. And so we ask that all presenters and attendees are aware of this when engaging with the content shared. Taking that this workshop will be fully held online, it is not unlikely that speakers or presenters, due to technical and/or other reasons, may find difficulty to join and present. We will need to be flexibly responsible to fill such gaps whenever they arise, and ask you to bear with us as the attendees of this year's workshop. Going back to today's agenda, you will notice the structure of the day is split into a lecture session, break, doctoral candidate presentations, and then the closing. During the lecture session, each speaker will have 30 minutes or longer in the case of panel sessions, which will be utilized at the discretion of the presenter. We will then have a Q&A session and discussion with all of the presenters at the end of the lecture session. After, we will have a brief break for everyone to grab a coffee and stretch their legs. Then we will move on to the doctoral candidate presentations, which will consist of a 10-minute presentation and a 10-minute Q&A for each candidate. The Q&A will begin with a question for an expert and then move to the floor for questions in a closing question session. If your question does not get answered at any given moment, then we will try our best to fit in your questions at various stages throughout the day. Before we move on to our lecture sessions, and since we still have Professor Oliver Ruppel and Professor Patricia Kameri-Mbote with us, I would now like to open the floor to our attendees to see if they would like to engage with our opening presenters. If you wish to engage, kindly raise your hand or post something in the chat for us to read aloud. I have a message in the chat. It is addressed specifically to Professor Kameri-Mbote. Dear Professor Kameri-Mbote, how do you feel the expansion of UNEP in recent years has promoted to the establishment of climate law as it stands? And what can be done by international organizations to ensure that there is a further development for climate change and protection? Over to you, Professor.
Thank you very much for the question. UNEP is singularly concerned about the three interconnected crises, like I said, which is pollution, biodiversity and nature loss, and climate change. And the climate change is addressed in two divisions of UNEP, namely the industry and economy division, and that is where the issues of net zero, the issues of just transitions are addressed, and also in the ecosystems division. We in the law division, of course, play the supportive and enabling role as a foundational program. And there is very keen awareness within UNEP that there is need to deal more closely with climate change. In fact, if you look at, I was talking about the Ozone Action Branch. The Ozone Action Branch is the branch involved in implementing the Montreal Protocol for ozone depleting substances. Whereas for the longest time, there was not seen to be a link between ozone depleting substances and climate. With the Kigali Amendment, now the focus on hydrofluorocarbons is putting a beamer on the role that ozone depleting substances and what we work with cooling could do to climate. And in fact, addressing these HFCs is seen as capable of helping us reduce temperatures by 0.4 degrees, which is not a little amount. Yeah.
Thank you, Professor Kameri-Mbote. We have another question for Professor Oliver Ruppel. As the director of the Research Center for Climate Law, what do you feel is the role of research centers in promoting doctoral research in the field of climate law?
Thank you, Larissa, and thank you for the question. As I've mentioned, if we want to get a grip on one of the most pertinent problems of our time, it is fundamental to engage in cooperation at multiple levels. Research centers around the world can serve as platforms for exchange, can also connect dots between science and policy, between law and politics, between legislation and implementation. They can connect dots between the youth and diplomacy, between children and courts, between indigenous people and the industrialized community. And in that sense, they can span a network around the world where doctoral students could also serve as ambassadors, delivering messages of the future, as Dr. Ginzky said, also in terms of contributing to a transformative form of justice, a transformative form of the design and implementation of the law, but also bring in young innovations and to inform existing structures of new ways of thinking. In that sense, I think it is a great opportunity for such centers to connect to not only academia, but to involve young researchers to grow rapidly into a field that is complex, that is transdisciplinary, that requires exchange, also perhaps even confrontational exchange, if we look at court cases. But I think intellectually speaking, the centers are fora for open ways of thinking, for discursive ways of thinking, and for cooperation where also exchange with perhaps industry partners can contribute to new partnerships and to new programs where doctoral students can be involved, hands-on involved, also funded perhaps for that matter, which for young people is not seldomly an important point. In that regard, I think the opportunities are endless, but the network must still grow. And I think the mere fact that we have partners as the United Nations Environment Program around the table here, or the German Environment Agency, shows that there is momentum, positive momentum that will also contribute to new developments, and which makes me optimistic for our role ahead.
Thank you, Professor Ruppel. I have one more question for both Professor Ruppel and Professor Kameri-Mbote. It reads, having been involved in a number of international organizations, do you believe that there is more room for international cooperation, and how can this be done in the future?
Absolutely. There is a lot of room for cooperation. I mean, when you're dealing with the problems such as the one we're talking about today, which is climate change, and I think we have all underscored the fact that this is not national, it's actually transboundary, and it's actually also ubiquitous. There is definitely no way that any one actor is going to be able to deal with climate change without the engagement of others. So I think there is room for cooperation, and when we hear a lot more these days about the need to upscale multilateralism and to have a multilateralism that is networked and that is inclusive, because all these issues that are going to be dealt with here in the next 5 days require different actors to work together. And the inclusive network multilateralism is the way to address the problems that we currently face.
There's basically little I can add to what Professor Kameri-Mbote said. I would just like to give one positive example of how cooperation can be a game changer. And taking that we have Professor Kameri-Mbote with us, I would like to make reference to ASSELLAU, one of the partners in this program, the Association of Environmental Law Lecturers in African Universities. That, Patricia, correct me if I'm wrong, was founded almost 20 years ago by Professor not Odote, but Professor, give me the name, please.
Okidi.
Professor Charles Okidi, yes. So Professor Okidi passed away, but he embarked on this project when Africa was probably free of environmental lawyers altogether. So it was a very, very new way of thinking to foster a field of the law that until then probably didn't exist in our curriculum. There were a few cases before African courts dealing with the subject matter. And he started to build an army, and I quote Professor Kameri-Mbote, an army of environmental lawyers for Africa. And I think that is an achievement that is a reflection of what cooperation can do, of what intellectual exchange can move forward. And we see so many cases now in different African jurisdictions, but we also see a lot of African scholars in international organizations, at international courts, and so on. And I think a lot of that goes back to the ambition to build an army of environmental lawyers for the African continent. That's only one example, but it, for me, is a very strong one. And Professor Kameri-Mbote has taken over this torch from Professor Okidi, and I think we should do the same in the context of climate law and climate policy to move the subject matter ahead. Back over to you, Larissa.
Thank you once again to Professor Oliver Ruppel and to Professor Patricia Kameri-Mbote for their opening remarks and for adding such valued information to the start of our PhD workshop. I would now like to move on to our lecture sessions. Today we have 3 distinct lecture sessions that are taking place, and the first is by Professor Christina Vogt, who has joined us all the way from the University of Oslo in Norway. Professor Vogt is a professor at the Department of Public and International Law, and she's also the chair of the IUCN World Commission on Environmental Law. It's a pleasure to welcome you today, Professor Vogt. Over to you.
Thank you so much, Larissa, and thanks for inviting me to this PhD workshop, the PhD seminar. I just joined about 3 minutes ago, and I'm very sorry to have missed Patricia's and Oliver's talk. I'm so sorry for that. I could just hear your last words, Patricia, but I send my regards to you and to Oliver. It's very nice to see you. And I would like to say a very warm hello to all the PhD students, not just for joining here as today and for engaging in this discussion, but also for your interest in this topic, because it's an absolutely crucial one. And as Oliver just said, and Patricia can, I'm sure, second, is we need an army of lawyers in this field, because at least from my field of work, I do know that lawyers are needed. We've had an era of science and an era of politics with regard to climate change, but now it has come to the era of law, and that in terms of legislation, but also, of course, in terms of litigation. And I see that both aspects of climate law are the topic of this workshop. So congratulations to you, Larissa, for conceiving this very important topic, and congratulations to everyone for joining and for being interested. Now, I will talk a little bit about the role of the Paris Agreement in interpreting human rights law. This is a bit of a convoluted topic, and in order to get there, let me just take one step back and say a couple of words about why climate change is such an important topic to deal with, and then I'll move into this issue of treaty interpretation of other areas of law in the light of the Paris Agreement. Now, I'm sure you addressed in the first couple of hours that you already had, or hour of this workshop, the issue of climate change being an existential threat to basically everything we do. If climate change is not managed and halted at safe levels, it will lead to consequences that are unmanageable, that are unplannable, and that lead to many places on this planet becoming unlivable. In other words, it's going to be deeply disruptive to the relative stability that humans have experienced ever since human systems and human societies evolved. And these are perhaps sentences that you've heard many times before, but it's very important to digest them and to understand what this means. Because if not managed, climate change will lead to a world that is warmer or hotter. It's wetter and wilder, and we already see this. We just have to open the news, or it just comes at us and the news coverage. But it also will lead to a world that is immeasurably different from the world that we know. And every degree of warming, and actually every ton of CO2 or every ton of greenhouse gases emitted into the atmosphere, will increase the likelihood of droughts, fires, floods, and famine, and create risk for ecological systems and for human society. Now, this is just the backdrop of why we will talk about human rights in this context. You can already perceive that by these impacts that I mentioned, droughts, floods, fires, famine, human displacement, these all have effects, these all have impacts on human enjoyment of human rights. And the IPCC is very clear. The IPCC, if you had a look at the 6th assessment report, which consists of 3 massive sub-reports, and it's thousands and thousands of pages to read. But if you want to comprime this a little bit, I recommend that you maybe have a look at the synthesis report of the 6th assessment report, which is only a couple of pages, which was released earlier this year. But please go back to the overall report, because that is where you find most detail on some of the legal and governance issues, some of the impacts on human rights enjoyment. You won't find this in the assessment report, in the synthesis report, but you find links back to the overall report. But the IPCC is clear that the extent to which current and future generations will experience such hotter and different world from the one that we know, from the one that exists today, will depend on the choices that we do take now. And the choices that we take now will have effects for now and thousands of years to come. These are exactly the texts that the IPCC used. And it always gives me a shiver down my spine when I think about that, what the choices that we take in this decade, now, today, will have impacts for thousands of years to come. Now, where does the Paris Agreement come into all this? Well, first of all, the Paris Agreement, of course, is, as per, I hope you know, it's an international treaty. It's legally binding on 195 states, and it sets a global travel of direction, in particular in its temperature goals that we find in Article 2, where it provides us with the global consensus on that safety threshold. It's clear that we won't be able to completely stop climate change and global warming, but the question is of how much can we tolerate, and when is the threshold? That is what we find in the Paris Agreement, and it is defined as holding temperature increases to well below 2 degrees and pursuing efforts to holding it to 1.5 degrees compared to pre-industrial levels. And you probably have heard about these temperature goals or read the text of the Paris Agreement. If not, then I recommend you to do so. So that is the global choice that already has been made, and it's normative anchored in that global treaty, almost universal treaty, the Paris Agreement. Now, when we look at the agreement, we will find that it doesn't answer everything. Of course it cannot. It's not a silver bullet. Now, it doesn't contain much on human rights. It has a reference to human rights in its preamble, where it basically says that when states take climate action, they have to be mindful of their existing human rights obligations. And I don't know if Larissa mentioned it, I worked as a principal legal advisor to the government of Norway for more than 10 years and negotiated for Norway several parts of the Paris Agreement, including the reference to human rights and other aspects. So human rights and what kind of obligations states have under their existing human rights treaties, obligations, UN human rights treaties, domestic human rights laws or acts, is not something that the Paris Agreement from the outset deals with. There are many other things that the Paris Agreement doesn't deal with, for example, migration, or how to conduct trade or investment, or how to protect the oceans. These are all dealt with in other international treaties. Human rights treaties, law of the sea, Convention on Biological Diversity, WTO, and so forth. But does that mean that these other treaties exist in isolation from the Paris Agreement? In these other treaties, for example, human rights treaties, the United Nations covenants on human rights, they don't mention climate change. They don't mention the environment at all, because they were negotiated and conceived right after the Second World War. And at that time, environment or climate change wasn't really part of the global political agenda. So they were not negotiated with climate change in mind, and you don't find any reference, at least in the European, the UN human rights system or the European Human Rights Convention. You don't find any reference to environment or climate change. So are they therefore irrelevant? Of course not, because you know that no treaty is an island in itself, and no treaty is set in stone and does not evolve in its understanding over time in the context of contemporary issues that the global community is dealing with. These international treaties, including human rights law, will have to be interpreted and applied in a contemporary manner in the context of climate change. Now, this is not an easy task, but for lawyers, it's something that is not impossible. So ultimately, what I'm trying to say here is that human rights treaties will have to be interpreted in the light of the Paris Agreement. There are a couple of methodological reasons for that before I go to actually what it means to interpret human rights law in light of Paris Agreement. When it comes to the question of saying how, what is the legal methodology to be applied? You can either look at general international law, in particular the Vienna Convention on the Law of Treaties, and you may know that Article 31(3)(c) requires or allows treaties to be interpreted within their international legal environment or framework within which they exist, where it says that in the interpretation of an international treaty, account should be taken of any relevant rules of international law applicable in the relations between parties. And here, of course, the question is, do we mean parties to both treaties or just parties to a dispute? And I have a tendency to follow the latter because we don't really have absolute equality of parties to all international treaties, and that cannot be meant in this particular provision under the Vienna Convention on the Law of Treaties. Otherwise, it would be meaningless. But you can also look at the legal doctrines that international courts, in particular human rights courts, regional human rights courts, for example, European Court on Human Rights or the Inter-American Court on Human Rights, have developed in the context of how human rights treaties are being interpreted. When it comes, for example, to the European Court on Human Rights, and you know that there are currently 9 climate cases that are being scheduled to be heard throughout this and next year, the European Court on Human Rights applies something called the European Consensus. Other international courts employ other doctrines, for example, doctrines of living instruments. But the point is that the treaty under which or over which the court has jurisdiction is not set in stone. There are legal methodologies that allow to take into account the normative framework within that particular treaty exists. Now let me go to the substantive part of my brief talk here. What does it mean to interpret the standard of care contained in human rights treaties in the light of the Paris Agreement? As you know, states have positive obligations to protect individuals under their jurisdiction against human rights violations, and that includes impacts of climate change. And in this context, states have to take all adequate and appropriate measures. In particular, this is what the European Court on Human Rights tells us in terms of what is the standard of care for states to fulfill their positive human rights obligations. And in this context, when it comes to climate change, the Paris Agreement with its overall temperature guardrail or goals becomes relevant because in order to determine what are states' adequate and applicable measures that they need to take, we have to have an understanding of what is the general global consensus with regard to climate change. Where is our travel of direction? That is where the Paris Agreement comes in. So the temperature target, the temperature goal that I already mentioned, with keeping warming well below 2 degrees, pursuing measures to 1.5 degrees, is guiding in the interpretation of states' the content of states' positive obligations. Keep in mind here that when we look at Article 2 of the Paris Agreement, as we know, there are 2 temperature goals, well below 2 degrees and 1.5 degrees. And for quite some time, it was a bit of a struggle of like what exactly is the temperature goal of the Paris Agreement. What we know now is that for the last 2 global climate meetings, the Conference of the Parties that took place last year in Sharm el-Sheikh, and the year before in Glasgow. Well, they take place every year, but for the last 2 years, all the parties to the Paris Agreement have resolved to taking efforts to limit temperature increases to 1.5 degrees, which means that there is a normative tilting towards 1.5 degrees rather than just well below 2 degrees. And there is subsequent practice, there is subsequent understanding of the parties to the Paris Agreement that 1.5 seems to be the threshold that matters rather than just well below 2 degrees. And you can read that directly from the decisions, the consensus-based decisions taken by all parties to the Paris Agreement. So what we can derive from that is that there is a general standard of care to pursue efforts to limit temperature increases to 1.5 degrees. Now, does that say much to us in terms of what each party has to do in order to protect human rights of their individuals that may be affected by climate change impacts? Not very much yet. 1.5 degrees is quite an abstract global temperature target, which needs to be broken down to what each and every state actually has to do. But this is also something we find in the Paris Agreement when we look a little bit further into it. In Article 4, paragraph 1, it states that in order to comply with the temperature the global temperature targets, states aim at global peaking of emissions, meaning it's not increasing anymore, but peaking and then going down. Global peaking as soon as possible and deep reductions thereafter, so as to achieve a balance of emissions and removals in the second half of the century. This is sometimes also referred to as climate neutrality or net zero greenhouse gas emissions. That might be a term you have heard before. And the fact that net zero is suddenly everywhere, it's not just states that have net zero targets, but even cities and schools and universities and companies is something that quite surprisingly, but it was derived from the Paris Agreement and that goal of balancing emissions and removals, which I said is just another way of saying net zero net zero emissions. And this is exactly in line with what the IPCC said in its 6th assessment report, which was just published a little while ago, where the IPCC, the Intergovernmental Panel on Climate Change, identified very clearly that pathways that still have a likelihood of not overshooting 1.5 degrees, that these pathways of emission trajectories will see deep, rapid, and immediate reductions of greenhouse gas emissions, in particular CO2 emissions. And here we have finally a number where the IPCC is talking about 45% of reductions by 2030. This is the end of this decade. It's really just around the corner. 45% by this decade and reaching net zero by 2050. And that's not the end of the story, because once we've reached net zero, the curve has to go further down below zero, because greenhouse gas emissions have to stay net negative all the way to the end of the century, which means that from 2050 to 2100, we actually have to make sure that more CO2 is somehow sucked out of the atmosphere and stored somewhere than it's collectively emitted by humans. So this is very clear indication from the IPCC, baked in or integrated into the Paris Agreement of what states have to do. And if we now use this as a means to interpret the standard of care under human rights law, it actually means that in order to comply with their positive obligations to protect human rights under UN human rights treaties, as I said, or domestic treaties, in particular, right to life, right to culture, right to private life. These are the rights that so far have been used and employed in litigation, both domestically, but also regionally at the European Court on Human Rights. But you may also know that the UN human rights treaty bodies, and particularly Human Rights Committee and the Committee on the Rights of the Child, have been quite actively engaged in complaints. And we recently had a decision by the Human Rights Committee in the Torres Strait Islanders case against Australia, where the UN Human Rights Committee, for the first time ever, gave an authoritative statement that states ineffective and untimely adaptation measures was amounting to a violation of human rights, here of an indigenous group of the Torres Strait Islanders, which are Australian citizens in Australia, by not building seawalls fast enough to protect the land inundation and the loss of land and loss of culture that goes with loss of land of those small islands of the Torres Strait, violated their human rights obligations. So we have international tribunals, quasi-judicial bodies engaging with the question of how can human rights obligations be interpreted in the light of climate change. But in this particular case, that dealt with adaptation action, insufficient adaptation action, dealing with the consequences of climate change, but not with a question of what do states actually have to do in terms of reducing their greenhouse gas emissions, their mitigation obligations. So going back to what I said about drawing the Paris Agreement into it, its temperature goals, breaking down of what it means in terms of greenhouse gas emissions, 45% by 2030, net zero by 2050, net negative thereafter. The argument can be made that in order for states to comply with their positive obligations to protect against the impacts of climate change, as a violation of the human rights obligation, they have to take, or they must take, all adequate and appropriate measures, which includes both legal, economic, administrative, institutional measures that are aligned with that goal, that are aligned with a global threshold of keeping global warming to 1.5 degrees, which in turn means that they have to have measures in place that are aligned with reducing emissions by 45% in 2030, reaching global net zero emissions by 2050 and net negative emissions thereafter. You cannot apply this equally to every single state. There's an issue of global equity, where developing countries may have a longer time to reach these goals than developed countries, but still the global trajectory, the global goal where we all have to be by 2050 and thereafter is very clear. And in this context, it may also be relevant to remember that states have committed, all these 195 member states, to the Paris Agreement. It's, as I said, it's almost a universal agreement. There are only a very handful of countries missing who have not become bound by the Paris Agreement. So the parties are committed that their nationally determined contributions, their climate plans, which they have to communicate every 5 years. The next time around, it's in 2025. So it's 2 years from now, that their nationally determined contributions reflect their highest possible ambition. And that highest possible ambition need to be seen in light with where we all need to go. They has to be seen in light with the overall temperature target and in light with reaching net zero, global net zero emissions around 2050 and negative emissions thereafter. And that every time parties put forward a successive NDC, a new one after 5 years, it has to progress in their level of ambition. Which goes back to the maybe some of the criticism that you may have heard or picked up as to the effectiveness of the Paris Agreement, that it's not yet, the level of ambition on parties' NDCs is not yet commensurate to where they need to go in order to keep warming to 1.5 degrees. But this is expected. This is the whole point of why we have the Paris Agreement. The whole point is that in regular intervals, every 5 years, every party has to put forward a new and better progressed NDC and has to be transparent to everyone, not just to all other parties, but to the whole world, on how well it is doing in implementing and achieving its NDC, given the fact that the target in the NDC itself is not legally binding. As you perhaps know, that was one of the compromises that needed to be agreed on in Paris itself. But parties have to reflect in their NDC their highest possible ambition, which is kind of a due diligence requirement. They have to do as good as they can. They have to do their best effort, put all appropriate means and adequate measures into their NDCs. And that reinforces, again, the understanding of human rights law as to what all their positive obligations are. It can be read and interpreted in light of the Paris Agreement. Now, if a court, and that's just to wrap up, to maybe have one or two questions. I don't know, Larissa, if that's something you would like to give students a possibility to, I'm happy to. It doesn't mean that a court that is asked to adjudicate on human rights obligations of states with regard to climate change, that a court would have to say exactly how much each state would have to reduce in terms of what percentage. That's, for example, France or Pakistan or India or China have to reduce. But a court would have the possibility to review states' measures and acts and regulatory framework on whether it is in line with the global normative framework of the Paris Agreement and informed in light of science. So it's not, a court would not be called upon to determine the exact amount of greenhouse gas reduction required. That, in my view, would not be possible for anyone, not a court either. It's really, really hard to say what exactly would be like the fair share for each country. That has never been possible in the international negotiations. And I can, for the heart of me, not see that a court could do it, but a court could ask and assess whether the measures adopted by a state are reasonable and adequate and in line with the 1.5 degree target and in line with what the IPCC tells us about the time frame to reach net zero, global net zero emissions and net negative emissions. And that general alignment is something that a court could assess and could send back to a state saying, please revise your normative framework, please revise your climate act or whatever it is, in order to bring it in alignment with that global goal. By reflecting your highest possible ambition, or by doing the utmost that you can. But I think I will leave it here, and I'm happy to take any questions or comments that there may be. I see we have maybe some 5 minutes left, Larissa, if this is the case, and I'm happy to take questions. Thank you, and with that, back to you.
Thank you, Professor Vogt. That was truly insightful, especially at the beginning of our workshop, to draw the correlations between the Paris Agreement and human rights, generally speaking. I do have one question that has been posted in the chat, and then maybe we can address this question and then move on to our next panel session. But the question was, with each COP, we see greater efforts by states to address climate change. However, was this movement done too little, too late? 2030 is just around the corner. Do we have enough time? And what implications does the global stocktake have in this regard? I know it's a very long question that can be answered by its own presentation, but just your key takes on this would be greatly appreciated.
Well, is it too little, too late? And are COPs just talk shops? that maybe is the core of the question. COPs are so many things. COPs, of course, have the formal negotiations, but this is the smallest part of a COP. I mean, I've been a negotiator for a long time, but the negotiations, they happen the very tail end of the COP, where you almost don't find the rooms. But there's so much else going on, which is more of a network building and side events and, you know, all these like a climate fair. And all this is now the COP. But when we go to the formal negotiations, because this is, by the end of the day, I think for lawyers, this is what really matters. We do see that there is progress, there is movement. It's always incremental, it's always slow, because decision making is by consensus. And, you know, getting everyone to agree on something when you have 195 so different states, and where climate change is an issue of global equity, of global justice, that has its roots back for 150, 200 years. At the same time, it has to look like 150, 200 years into the future, or thousands of years, and has economic implications. It is difficult. It is really, really hard. So getting to consensus is difficult, but the tiny little steps that are taken every year matter, and they're really important. And as I said, for the last couple of years, we've seen small developments in terms of, you know, committing to 1.5 degrees rather than well below, addressing loss and damage as we did now last year in Sharm el-Sheikh, and many other aspects. It is slow, but it is something that we can't do without. But it has to be accompanied. It has to be complemented by bottom-up pressure, by peer pressure, by civil society pressure, in terms of getting parties to revise their NDCs at regular intervals and push up ambition. That is really, really important. The IPC tells us it's not too late if action happens. There is a high likelihood of overshooting 1.5 degrees, but there's a possibility to getting back to maybe 1.5 or 1.6 degrees. This is still better than a world of 3 degrees warming. And I think we wouldn't be on that trajectory without the COPs and without the Paris Agreement. But never be complacent. There is no time. You know, keep the pressure on all levels, and including your legal work.
Thank you, Professor Vogt. If there are any questions from any of the attendees, feel free to raise your hand and ask them out loud. If not, then I think we can move on to our next panel session. And once again, I'd like to thank Professor Vogt. I'm sure you had previously stated that you may not be able to stay for the whole entirety of the workshop, and so we appreciate you taking the time to be with us today, and we wish you a wonderful day further.
Thank you so much. I'll switch off my camera, but I keep on listening for a little while.
Perfect, thank you. I'd now like to hand over to my colleague, Carlotta Garofalo, who will introduce our next panel session speakers. Over to you, Carlotta.
Yeah, thank you, Larissa, and thank you, Professor Vogt, for your insightful presentation. So we will start now a panel discussion with two exciting speakers, Aditi Shaye and Paloma Costa. Paloma is not here yet, but we hope she will be able to join during the session. So Aditi is a qualified lawyer in India. She holds a Master in Global Environmental Law at Strathclyde University. She's currently a researcher for the Corporate Climate Litigation Project at BICL, and she has worked during the last couple of years in the World Youth for Climate Justice Initiative and organization. Paloma Costa is a Brazilian lawyer and a climate activist. She has been selected as one of the 7 youth climate leaders by the United Nations Secretary General Antonio Guterres to a youth advisory group. She has also worked in different organizations, climate change organizations, for Engajamundo as a national coordinator, and for ISA, the Institute for Social Environmental Law in Brazil. Paloma and Aditi have been lawyers in very different sides of the world, have practiced in very different legal traditions, but they have done something very similar. They have both engaged in youth-led initiatives to hold states accountable over climate change in action. So we think it's very interesting to hear their perspectives together today. And with this, I hand over to Aditi for our presentation.
Thank you so much, Carlota. Thank you so much, Larissa, also for having me. It is actually an honor to share this panel with Paloma and Professor Voigt and Dr. Hofer. So moving on to my topic, actually, Carlota asked me to share some observations with my work with World Youth for Climate Justice, which works on the International Code of Justice Advisory Opinion on Climate and Human Rights. So I actually would like to highlight some of the lessons we as World Youth for Climate Justice have learned and how we endeavor to use law as a tool to campaign for climate generally. So at the outset, it is important to note that youth engagement has played a key role in tackling climate policies and the decision-making processes. The United Nations has recognized the need for youth engagement bodies and also has worked closely with youth-led and youth-focused organizations through the United Nations Joint Climate Framework on Children, Youth, Climate Change, the Joint Framework Initiative, actually. Yeah, and UNGO and other bodies such as UNGO are under the auspice of UNEP, CCC, and other 15 other legal frameworks, as also highlighted by Dr. Voigt, was the Biodiversity Convention, the Desertification Convention, the Conventions on Development, and Child's and Women's Rights. So having said this, there is already recognition that civil society and youth engagement plays an important role in these processes. So at World Youth for Climate Justice, we just while we began campaigning for the advisory opinion from the International Court of Justice, we thought that we could use this and campaign for ambitious climate action at the UN level and the high level generally. And from not just from a civil society perspective, but also involving the law to make it more meaningful, to open it to participation from a legal base or from a legal perspective. So while we began this, I think there are a few lessons. There are actually many lessons that we learned, but like I will just try to summarize a few of them in the interest of time. Is that the first one is that we realize that these efforts really need to be strategically coordinated. And when they need to be strategically coordinated, that means that we also need to have meaningful participation from both ends, that is the high level and from the young people who want to make an impact and who strive to make an impact. So we realize that your law, generally the rule of law, plays a major role in making this in making this participation, or like enabling this participation in these high level processes. So most of the frameworks are generally based on principles of public international law or customary law, as Professor Voigt highlighted, and they are interdisciplinary, and they cannot, and climate is a subject that cannot work in isolation. It always has to be considered together and very forward looking, but also backward looking. So so to get this to participate meaningfully and to come ready to the table with our demands, with youth demands generally, we realized that knowing the basics of these legal processes was a game changer. We also learned that if we had to lobby at the UN level to get the resolution in the first place and then go to the ICJ, we would need massive support from civil society to create that psychopolitical pressure. But this also meant that we had to translate all these legal processes, all these complicated UN processes into a simple and understandable language for those who do not necessarily have a law background or who do not necessarily have a political or a socio-political background. So that was one of our main processes while we began campaigning for the AO. And as complicated as getting through the UN process from the UNGA process was, we tried to make it as simple as possible to build capacity around different regions that we work in. So we have regional fronts in Asia, in the Pacific, in Latin America, in Africa, and obviously in Europe. So we try to build capacity, we try to engage with youth, we try to speak to law students, university students from all around the world to band them together and to speak to existing civil society and youth societies to ask their states to be part of the UN process for the AO. So generally, it was more like translating these legal processes into simple language and letting people know, letting civil society or like the younger generation know that there can be meaningful participation, it is important, and why it's necessary for them to participate, and how their participation would change the process, or rather would impact the processes, and how state behavior hopefully can be influenced by it. So that was the first part of that was the first phase of the campaign, and that's how we learned, or that's also was a learning process, but that's how we realized we need to engage in civil society and make this process simple. So that was one of the first lessons. Another thing was that because the campaign is legal in nature, we realized that we need to base our demand, like how we base our demand and how we base our arguments are important, because we're looking at climate law and we wanted a sort of we wanted a progressive opinion. We wanted an opinion that looks forward while also understands the intricacies of looking backward. So that was one of the thoughts that we put into how we can use this, and how we can again simplify this, because these are all very legal terms, and everyone and students, or just generally people who do not have the background, get lost in these, and they get lost in all this translation. So that was one of our main aims during the first phase of the campaign. And it's always tricky to navigate these UN processes. And while we did that, we needed support, and we did get support from experts who know the ins and outs of these processes. It was through the guidance of all the wise heads like Tony Acosta, David Foreman, Alan Wert, Stina Figgers, Justin Rose, and obviously our colleagues at Blue Ocean Law, that we could catalyze these efforts into something that we can be used, and civil society can generally understand and support us in doing that. So, as I said, the first phase of the campaign went into mobilizing the support for Vanuatu and requesting the UNGA to pass the resolution. Now, as we come on, now that's done, and now we are going on to the second phase. That again is based indirectly, but yet on meaningful participation, because we realize that we are a youth organization, we are an NGO, and we technically cannot make these submissions before the ICJ. So our strife was to approach states, to mobilize states, and to submit our demand to them so that they can use our demand and then put it forward to the ICJ. And that was one of our pillars, like meaningful participation was one of the pillars of doing that. And to do that, we then, coming to the next part of my topic, would be how we use law as a tool for youth climate activism. And while we wanted to make our demands to state, to submit them to the ICJ, we decided to publish a Youth Climate Justice Handbook, which basically, and we did that along with Pacific Island students fighting for climate change, in which the handbook basically is 3 legal documents. It was drafted by young lawyers at WICJ with the help of international lawyers and obviously academics who are experts in the field. And the handbook consisted of 3 major documents. One is a summary for policymakers. The second is the legal memorandum, and the third is the status report on legal principles of international and human rights law relevant to climate change. The purpose of publishing the legal document, as I said, was to make sure that our demand goes to the ICJ and we can take it to states and let them know that this is our demand, this is what we want, and it would be your responsibility, because we are your citizens, to take this to the court and submit it, because our campaign was based on laws of intergenerational equity, and that is what we are looking forward to, and that's the reason why we started the campaign. So in doing this, the legal memorandum actually responds to all these questions that are posed by the UNGA to the ICJ on climate change. And the summary of policymakers is essentially synthesizing the legal memorandum, and these documents essentially are intended to inform states and their legal advisors, their policymakers, and also youth to demand how they can be incorporated in their submissions to International Court of Justice. And another intention was to set an example for youth and civil society regarding how young lawyers can actually participate or make a mark while they're still not technically allowed to go before the court, like in likes of the ICJ. So that is one of the main methods of how we meaningfully participate and how we use law as a tool for climate activism. Coming to the next part would be now since we've been campaigning, we also as the trends of AOs are increasing from different international tribunals, we will also be making submissions to the Inter-American Court AO as WICJ. Another important point was that we need to make it as accessible as possible. So we decided that we're going to make 2 different submissions to the Inter-American Court, and this was only possible because the Inter-American Court is a court that considers or takes into consideration submissions that are not necessarily from states. So that also sort of gave us a tool for us to be present and put our demands forth and look into it in a way that they could synergize, because it'll be either the Inter-American Court AO that will come first, or the ICJ AO that will come next, and then the ITLOS AO, which actually technically will be the first one that will give us AO. But these things would help either of the court, the jurisprudence given by either of these courts would help the other court to understand what is needed or what is essentially demanded. So that's another reason why we decided to make these submissions, make this a meaningful sort of participation, so that we could influence states as well as make sure our demands are put across. So in terms of the Inter-American Court of AO and also for accessibility, we're gonna make submissions in Spanish, which will be taken forward by the Latin American front, and they will be more accessible to the people of that region than other Spanish-speaking people. And then we're going to have an umbrella submission from WICJ generally in English, so that people who also don't speak Spanish can actually come and partner with us to take this forward. So these are various ways in which we are trying to use law as a tool, and as most of us are young lawyers, we're trying to make as much as possible of whatever we can get hands on, all the opportunities that we can get hands on. Now, coming to the end of my talk, just a few points to conclude is that what actually do we get out of this, and what is our hope? So I think this is going back to Professor Voigt's point that we need an army of lawyers. So that is what we are trying to create. We are trying to create an army of lawyers who are going to be experts in this field, in the climate law field, in the human rights field, and see how the interdisciplinary how these fields work in together because they are interdisciplinary. And the first intention would be to have climate-friendly legal practices, not just internationally, but also domestically. The second important intention would be to make sure that this is happening in conjunction with the UNFCCC processes, making the UNFCCC process just like the COPs that happen every year stronger, and giving states and negotiators and lawyers material, and making sure that our demands are put forth through these legal tools that we are trying to use, and making sure that these processes become stronger rather than them being derailed or anything like that. So that's another important point. And the next, and looking forward into it, would be that once all these AOs come out, even though they're technically non-binding and they're just advisory in nature, there is still a large capacity that they could be implemented, or they could be used as basis, or the jurisprudence will be used as basis in domestic litigation, in regional litigation, and thus create ambition in states, mostly developing countries, where there are a plethora of issues that need to be considered while considering while considering climate policies. So like equity, like human rights, like food security, etc. So that is another important ambition, or rather important goal that we have. And then, should the court, any of the courts, touch upon the issues of procedure and evidence, we are hoping that jurisprudence will be slightly stronger in terms of evidence and procedures, in terms of how science is interpreted, because it's all there. It's just making the connection that is that lacks evidence, or that lacks, or has gaps. So that is another important goal that we are looking forward to, and hopefully using this kind of jurisprudence to make it stronger. And lastly, for it to be more rooted, even more than it already is, in accelerating domestic climate litigation, and essentially making sure that states have ambitious goals and climate policies, and they're aligned with, as Dr. White also very rightly said, aligned with the Paris Agreement, or other agreements that are to come forward, are to come in the future, which will be binding and mandatory. So I think I should stop there, because I need to leave some time for Paloma. So if there are any questions, I'm happy to answer them in the end or now. And I'm just going to give it back to Carlota. And thank you so much for having me.
Do we have any question from the audience, Larissa?
Yes, I have a question from the audience. Basically, the question fringes on your translation of legalese for accessibility purposes. So I think the main issue is, especially when dealing with cases or litigious examples, when providing this to possible communities, to youth at large, the problem becomes accessibility. How do we translate legalese into something that is understandable, but that doesn't minimize the extent of the legal background and legal phenomena that we are trying to achieve? So based on your personal experience, what do you feel were the key takeaways for translating what tends to be a really complex exercise of putting together a case and bringing forward litigation, generally speaking? What would you say were the key points in ensuring this accessibility in terms of translating the legalese to the youth and to other communities?
Thank you. That is actually, while it's a very important question, it's also something that we are learning to navigate now, because yeah, we realize that while we say this, while we do this, we can't really leave communities or children behind. And as I said, not everyone has the privilege of understanding or just the interest even for understanding these legal, complicated legal processes. So what we try to do is, while maintaining the integrity of the process and the understanding of the law, we, as a youth organization, as WYCJ, we try to come up with small snippets or blogs or even flyers and 1-pagers, 2-pagers that are explaining certain processes. And while we mostly do this in English, because most of us speak English, we try to also translate it into as many languages as possible, at least on a website, or at least when we are producing anything of our own. They're not, full disclaimer, full caveat, they may not be correct translations because we use AI, because it's just, it's just so much in our capacity that we can do. But yeah, through blogs, through workshop seminars, through building capacity, also like, actual capacity building events in different areas of the world, we try to make this, the main goal of these capacity building workshops is to make sure that it is open, it is accessible in the sense that it could be understood by people who do not have a legal background, or who do not necessarily or are very new to the UNFCCC or any of these high-level processes. So that is one of our goals. That is what we strive to do. We're definitely learning through the process, and there's a lot more that we can integrate in the future, I'm sure. But that's how we are approaching it. And yes, of course, like if there are any other suggestions and comments regarding it, we are always happy to hear and take it. So yeah.
Thank you so much, DT, for that very apt way of putting together quite a very complex question. As you've said, it's a process of building the ship as you sail it, and it's great to see the initiative of youth-led organizations in bringing forward engagement, not only to the youth, but also to other participating communities. I think, like Professor Vogt said it, and you reiterated, we need an army of lawyers. And so hopefully this moves in the right direction. I'd like to hand over to Carlotta once again. I believe the next speaker for this panel is now with us. Carlotta, over to you.
Yeah, no, I think Paloma is here with us. Can you confirm, Paloma? Yes, she's here. So as said, just in a short words, Paloma is a lawyer as well and an activist, and she's also been engaged in climate change litigation in Brazil. And she'll talk about that today. Over to you, Paloma.
Hi, everyone. First of all, I hope you are hearing me. Is it okay? Okay. Thank you so much, Carlotta, for inviting me for this session. I'm very honored. I'm super sorry for arriving late. I made a misconfusion with time zone and so on, so very complicated. But I'm really glad to be here sharing with you what we've been doing here in Brazil, and especially how we were able to connect climate litigation with pushing for climate action, with pushing for more response from decision makers and people who are in this position of charge. So today I prepared to share like 2 actions that I participated actively during my activism, and that I believe they have like they're very important for the context that we have been living in Brazil and the one that we are living right now. The first one is called ADPF 760. It is an action that the main ask that we are doing in this action is for the national law of Brazil, which is the national politics on climate change, to be working, because there is a plan on prevention and control of deforestation in the Amazon and in the Cerrado. And during Bolsonaro's administration, it was very clear that this plan, this public policy, they were not functioning.
I think we may have lost Paloma due to some connectivity issues. I think maybe we'll wait a minute or two and see if she can reconnect and rejoin us. Until then, I actually do have another question for Aditi, if you are available. There was the question on providing a progressive opinion, but also looking backward. We know that often litigious work is not retroactive. So how have you found a way to address both the forward-looking and the backward-looking?
That's also a very good question, and perhaps this is, I'm going to start by answering with a caveat that it'll be the court and the submissions that the court will be informed by which it'll give the opinion. So this is me while answering the question, just being from a young sort of lawyer perspective, or from the World Youth for Climate Justice perspective, is that the second question if you read the resolution, talks about legal consequences if they are violated, then the legal consequences of violating the state's obligations, while looking at intergenerational equity and while looking at the protection of future generations. So that, I think, is a forward-looking sort of question anyway. The court would have the opportunity to talk about or just rely or talk or make or sort of give jurisprudence on all the legal the covenants that have been adopted very recently, and it's the first time that the ICJ will, or any of these international courts, and all the three AOs will be addressing climate change as an issue. So it really depends on how they look at it and how they could incorporate human rights issues and human rights protection issues while looking at intergenerational equity and rights of future generations and children's while including climate as a right in those human rights. So that would be sort of a forward-looking or a progressive sort of opinion in that aspect. I'm sure there are other aspects as well, but this would be one of the points that WICJ sort of emphasizes on, and while still looking at it backward would be then, I mean, there is the principle of the CBDR, the common but differentiated responsibilities and respective capabilities. So while considering that, while looking into that, while interpreting that even further than it already is, the court could still have a chance to look at what has happened, and then while looking at what has happened through CBDR, they can look at what could happen and what should or should not happen. And as I said, while all of this is coming from my perspective, rather World's Youth for Climate Justice perspective, there could be a lot of other principles, a lot of other legal issues that could be raised. And also, since since it's something that's going to happen in the future, it really depends on how states also submit their submissions and how those are interpreted. So yeah, I think that is how I would sort of stop my answer to this question, and yeah, give it back to you, Larissa. Thank you so much.
Thanks so much, Aditi. I have one final question. It seems that unfortunately Paloma will not be able to join us due to connectivity issues. This is what happens when we have an international conference in various time zones. So before we move over to Dr. Hofer, we have one question, which I suppose, Dr. Hofer, if you would like to as well, you're more than welcome to answer. This question specifically speaks to the request for the advisory opinion on the obligations of states with respect to climate change. So addressed to Professor Vogt, to Aditi, and to Dr. Hofer. How do you foresee this advisory opinion impacting climate law and litigation, broadly speaking, especially if this advisory opinion is given and we have a clear oversight on what the obligations of states are? Do we see greater impact in terms of the position of states with regards to the Paris Agreement, with human rights, with youth involvement, also with the EU and their climate crisis measures? So maybe first, if we can move on to Professor Vogt, if she's still with us. Or maybe we first move to Aditi. Over to you.
Thank you, Larissa. As I said earlier, I think there are many sort of many layers in which this advisory opinion could help. It could, first of all, I think, as I said earlier, it's the first time that International Court of Justice is going to talk or even consider the issue of climate change. So I think that is novel in the sense that there will be jurisprudence that will be coming from the highest court with a lot of legal authority, with a lot of moral authority, and which is generally usually considered by other regional courts and also domestic courts to make certain, while they're considering novel issues like climate change in their jurisdictions. So for maybe a few courts in the Southern American continent, or even in the Asia Pacific, where a climate litigation case has not come forth, and it's the first time the courts that would be looking at climate as an issue in litigation, they could use the jurisprudence. They can look at the jurisprudence that the International Court of Justice will be putting forward, will be putting it out there, and consider it and use this as a precedent. So even though it is not necessarily binding, but for climate litigation, I think this could be a step forward. And I do understand that there are many cases that have come forward, that there's a massive array of climate litigation that's happening. But there are a lot of gaps in certain processes, especially in countries like in India or Pakistan, where while mitigation is still one of the top priorities, and if at all there is any sort of climate case, then mitigation is something that's always talked about first. Then and adaptation usually takes a step, is on the back footing. That could also be addressed in a climate case domestically. So I think that could be one of the ways the AO would help. Also, it really depends on what issues are raised within the AO and what sort of issues are talked about or touched upon in the AO respectively, in any of those AOs respectively. So I think that is something that's very interesting. And then, as I said, I think from a civil society perspective, I think another important thing is that it's raising a lot of awareness. Like we've managed to, there has, in the last 2 to 3 years, there has been a trend of these AOs coming up that is because of a lot of civil society pressure, a lot of demand from the civil society. And I think that also helps generally to create climate, like to push forward climate ambition in certain states. So I think that is another angle, sort of a non-legal angle to the AO being there, that the process of getting the AO, I think, also has made so much impact, very fortunately, that whatever happens at that level and when it happens is just going to be a cherry on the cake. And as Dr. Boyd also mentioned, that each and every the processes are usually incremental, but each and everything counts. So I think that is the perspective that WICJ generally takes, and that's the positivity that we bang on to work forward and make it forward looking. So yeah, I'm sorry I took a lot of time. Giving back to you, Larissa, Carlota.
Thanks so much, Aditi. Dr. Hofer, I'm not too sure if you have any other points that you want to add in this regard before we move on to your presentation.
You mentioned a lot of points. Yeah, what you mentioned, the most important thing is everything adds up to sharpening obligations and climate ambitions, and that is also true for the European Union. So the whole global framework of climate governance is influencing the EU climate targets and EU climate ambitions, and everything that adds up, every little piece, or more important piece like an advisory opinion will contribute to sharpening, to strengthening our efforts. But yeah, I think not so much for now. We will probably take over.
Okay, perfect. I think maybe we can move on to the next lecture session before we open the floor up to questions for all of our previous presenters. So the final lecture session for today is provided by Dr. Kameri-Mbote. Dr. Hofer is a postdoc researcher at the University of Graz here in Austria, and also a colleague of ours at ClimLaw Graz. She is researching in environmental law and constitutional law within the Austrian context, but also within the European Union at large. Dr. Hofer works on a number of project proposals and project research related to climate change law and litigation. Over to you, Dr. Hofer, for your presentation. Thank you.
Thank you so much, Larissa. Hello again from my side. I've prepared some slides and I'll just try to share my screen with you. Just a second. I hope that's working now.
It is. Thank you.
Perfect. So, hello again from my side. I'm happy to share some insights on European Union climate crisis measures today with you. First of all, okay, just a second, it's not working to. No, perfect. So, a brief overview over what I'm going to talk about today. First of all, I will address shortly the role of the European Union in tackling climate change. That is, how does the EU contribute to addressing the Paris targets? Then I will talk about areas and measures of EU climate action, and in the end address new progress, new challenges, some of the recent challenges the EU faces when tackling climate change. And to be honest, a presentation about climate measures of the EU that would probably fill not only today's session, but we could do the whole workshop only on the EU's measures if we discuss all of them in detail. So today I can only give you a brief insight, like just a short glimpse on what the EU does. But I'm trying to answer some of the general questions, and maybe some of those questions might be a bit repetitive for those who come from the European Union, but nonetheless really important to address them. The first is, what is the role of climate change in the structure of EU law? The second one, what are the EU's climate targets? And how does the EU contribute to reducing its member states' GHG emissions? And last but not least, how is the EU responding to new challenges? And what are the problems arising with that? So to start with, the EU, as well as its member states, are members to the Paris Agreement. The EU formally ratified the agreement on 5th October 2016. And as previously also for the Kyoto Protocol, there is not one nationally determined contribution for each member state, but we have a joint NDC for the whole European Union. That is, we have a joint target of emission reduction, and each member state contributes a tiny bit or a bigger part to achieving that goal. The initial NDC was at least -40% until 2030. The EU has already updated its NDC to at least -55% until 2030. And while the EU was still in the process of updating that NDC, and the European Parliament asked for even an increase to -60% until 2030. So still some time to go. Maybe we will start to increase again. For now, it's -55%. And as I already mentioned, this was not a new approach in the Paris Agreement, but we already had a joint goal emission target under the Kyoto Protocol. And as you can see, how the EU emissions evolved throughout the time, starting in 1990, we already achieved a slight decline of emissions. We could stick to our 2020 targets. The light blue line is historical greenhouse gas emissions without land use change and forestry, that is LULUCF. The darker blue one is the historical greenhouse gas emissions, including those land use change and forestry emissions. So including the removals by, for example, forests. And we have a projections with existing measures and with additional measures. You can see even the projections for additional measures, that is the dotted line you can see here, is still not on the way to reach the 2030 target for net emissions. So we have to plan a lot more emissions to reach -55% in 2030, but at least in general, we could reach a decline of emissions compared to 1990 so far. And split up to emission trading and effort sharing sectors. I will talk about that later, but in general, achieving the goal in the European Union is divided in the emission trading sectors, where we have an overall goal for the whole European Union, and the effort sharing, where the effort, or a few years ago, we talked about the burden of emission reduction. Now it's called effort to emission reduction, that is split between the member states. So you can see the amount of emissions in 2005, and with the dotted line, the goal in 2020 that could be reached. It could be reached in the ETS as well as the effort sharing sectors. However, that decline was also in 2020 also due to the COVID crisis. So for the ETS, we would have stayed within the 2020 targets also for 2021, but not quite for the effort sharing sectors. There was the goal of 2076, and we had 2,138 million tons of CO2 equivalents in 2021. As you can see, the dot gets really small for 2030 projection, so there's still a lot to do if the EU wants to reach its targets. For now, when you look at how the member states achieved the targets of 2020, most of the member states were on track with their EU goals. These are the yellow triangulars, only with additional measures like certificate purchase or international credits statistical transfer, but most of the member states were on their track of achieving the goals. This is how the EU aims to continue the process, of course. So we have a big interest on making sure that each and every member state fulfill its obligations also in 2030. And with that, we have established a multi-level system of climate governance for the EU member states that is drawing on international law, the Paris Agreement, other international conventions, also until 2020, the Kyoto Protocol, all those international law treaties and also informal legal documents, they all influence the EU law, the setting of the agenda on the EU law, and the EU law itself then influences the national law here for Austria. That is true for both primary law of the European Union as well as the secondary law. The primary law, these are the constituent treaties, the Treaty of the Functioning of the EU, as well as the Charter of the Charter of Fundamental Rights of the European Union, and the secondary law, which is regulations and directives aiming at a specific goal that could be like Renewable Energies Directive or Environmental Impact Assessment. And they all determine what the national law has to do in climate protection, and not like the normal legal acts, but also constitutional law. And in states like Austria, where we have the federal state and the Länder, the states, it influences both the federal law and the law of the federal states, that is the Länder. So with that, we have some general provisions and then some specific secondary legislation that influences what member states have to do for climate protection. And the role of the environmental protection and climate protection not only stems from those secondary legislation, that is directives and regulations, but it is also anchored in primary law as well, especially in Article 191 and for the following of the Treaty on the Functioning of the European Union. I've given you the text. It's starting with union policy on the environment shall contribute to pursue the following objectives, including combating climate change. And then the second paragraph says the union policy on the environment shall aim at a high level of protection, taking into account different environmental principles like the precautionary principle or the polluter should pay principle. Followed by that, we also have Article 11 of the Treaty of the Functioning of the European Union, which underlines that environmental protection, and that also includes, of course, climate change, these requirements must be integrated into the definition and implementation of the Union's policies and activities. That means in each and every policy and activity, we have to consider environmental impacts and also impacts on climate change. And as the Charter of the Fundamental Rights of the European Union is a relatively young charter, it specifically addresses not climate change, but at least environmental protection in general. We have Article 37 that states that a high level of environmental protection and the improvement of the quality of the environment has to be integrated into the policies of the Union and ensured in accordance with the principle of sustainable development. That is not a fundamental right. So you cannot get access to justice. It's not a subjective right, but it's at least a principle under that charter, and member states as well as the European Union itself have to observe the principles. So they have to stick to the principles and make sure that these aspects are considered in every policy measure. With that, the EU climate law has some specific structures and principles that can contribute to each member state achieving its climate targets. And the first and most important one is the binding character. We have, with the European Union, binding emission reduction targets EU-wide and for the individual member states. We have a direct effect and the primacy of application. As an example, I can give you the mandatory consideration of climate protection aspects in environmental impact assessment. So for every larger project, which could have significant impacts on the environment, we have to do an environmental impact assessment in the permit procedure, and in this permit procedure we have to consider aspects of climate change and climate protection. The EU law is enforceable. That means we can have sanctions for under-ambitious climate protection plans, failure to meet climate targets, etc. And the EU law also has an international orientation. The EU itself wants to set a good example, wants to be a role model, the first continent to be climate neutral until 2050. They are working on innovation and technology transfer, sustainable finance, carbon border adjustment mechanism, etc., etc. So the EU law doesn't only have effect to its member states, but also on a global perspective. When we compare that to international law, like for example, the Paris Agreement, the EU law in contrast is binding. So even if the targets of the Paris Agreement are not binding itself, through the European law, they get a binding effect for the member states. They have direct effect, so it's not depending on the member states to transpose that targets, but they have direct effect. The member states have to stick to them, whether or not they transpose them to their national law, and of course it's sanctionable. So I want to take the example of Austria and shortcomings in Austria's climate policy as an example to underline these structural principles. Austria has no emission reduction targets since 2020. We simply have no not any numbers or something on which emission reductions we want to achieve, because it wasn't they weren't able to achieve a political consensus on a amendment of the Climate Protection Act in Austria. And also, we have no specifications as to how climate protection is to be taken into account in a permit procedure. And the example of the expansion of the Vienna airport underlines very well the differences in how international law and EU law can influence a permit procedure in that given case. The Vienna airport planned to expand. They wanted to build a third runway strip. And in order to receive the permission, they had to, the authority had to rely on two acts. That one was the Aviation Act, the Austrian Aviation Act, which is not influenced by EU law, and the other one is the Environmental Impact Assessment Act, meaning that the authority has to conduct an environmental impact assessment. And first of all, the authority issued a permit to expand the airport, and that permit was subject to control of the administrative court. And the administrative court said, no, we have to take into consideration not only the airport itself, but the emissions of the airplanes under the Aviation Act, because of course the Aviation Act is old. The relevant provision was stemming from the 1970s, but now we have the Paris Agreement, we have emission reduction obligations, so we cannot leave that aside. And following that ruling, the Austrian Constitutional Court ruled that airplanes' emissions must not be taken into account, because the Paris Agreement, as an international convention, doesn't have a direct effect in Austrian law. We need to transpose that into national law, and if Austria is not doing that, since we do not have any emission targets, etc., the airplane's emissions must not be taken into account in that permit procedure at stake. So the Constitutional Court said, yes, we do have Paris Agreement, but we cannot take that into account in that specific permit procedure. Then the whole thing came to the higher administrative court in Austria. And this court said, yes, that's true. That's completely true for the Aviation Act, but stop. We also have the Environmental Impact Assessment. The Environmental Impact Assessment Act is relying on the Environmental Impact Assessment Directive of the European Union. And here is where climate protection aspects come into consideration. So even though the Aviation Act, stemming from the 1970s, does not consider the airplane's emissions, we have to take them into consideration because the Environmental Impact Assessment Directive asks us to do that. So we have a direct effect and a mandatory inclusion of the emissions of the airport in the decision for the permit to expand the airport. In the end, it granted the permission because it only took into consideration the emissions of landing and takeoff, so not really much of the real impact, and it granted the permission, but at least you can see here how European Union law can influence even the national law, even if in the absence of national law addressing climate change. So that is a big advantage of the EU climate law here. Okay, here I've prepared some recent highlights of EU climate action. Of course, it didn't all start in 2019, but just some recent developments I want to address here. The European Green Deal is one of 6 priorities of the current EU Commission working program. It's a set of policy initiatives with the overarching aim of achieving climate neutrality until 2050, so being the first climate neutral continent until then. And it was followed by the European climate law, which puts or transposes into law those policy objectives, especially the climate neutrality goal until 2050, some intermediate targets. And the European climate law was followed by the so-called Fit for 55 package, because one intermediate target was minus 55%, the European NDC to the Paris Agreement. And in order to be able to achieve minus 55%, in order to achieve that, to be fit for that, we have that package, that policy package stemming from July 2021, which includes a lot of different legal measures to implement that the target. I will talk about that later. And recently, we have Repower EU from May 2022, an initiative that aims at, due to the gas crisis, energy crisis, aims to reduce the European dependency on natural gas, Russian natural gas, and to accelerate the expansion of renewables. Also something on that later on, but that's just a brief overview. And according to that, we have EU's climate targets that have been raised or are in the process of getting raised. First of all, GHG emission reductions, as I mentioned, first minus 40, now minus 55%. Also, some targets for renewable energies. First, we had plus 32%. Now we have, or we are going to have plus 42.5, if possible, even 45%. And another goal for energy efficiency. First, it was minus 32.5% in energy consumption. Now we have minus 36%. And of course, the overall arching net zero target, climate neutrality until 2050. The EU has set a huge set of measures to reach these targets, and that's just an overview, and I will get to that different measures now. First of all, here you can see the Fit for 55 package includes a lot of revisions of different directives and also new measures. The first and most important measure of the EU to achieve its targets is the EU emission trading system, which stems from the cap and trade system. That means an installation, the owner of a industrial facility can decide to either reduce its emission on its own and then sell the surplus of emissions to another installation where the owner decided to not reduce its own emissions, but to buy emission certificates instead, in order to overall result to some cost-effective emission reduction. The ETS system was highly criticized, especially until the late 2010s, like 2018-19. It started to get more efficient. First of all, we had almost no effect due to over-allocation and low prices. People were making windfall profit, meaning that certificates were over-allocated and sold on the market. They received those profits without any effects. As you can see here on the price chart, the price even tended to go to zero at the end of the first trading period. But in the last years, there was a significant increase in the pricing mechanism, so that now the EU ETS has some significant prices for the emission permits, and it hopefully will get even more effective in the near future. The non-ETS sector, that is all those emissions which are not covered under the EU emission trading systems, especially waste, transport, industry, energy supply, and product use for smaller facilities, also agriculture and buildings, has no overall EU mechanism for reduction measures, but the member states are obliged to reduce emissions on their own, and there is a governance mechanism from the European Union. Each member state has a different obligation, a different target. These green ones are the ones where it was increased according to the raised NDC of minus 55%. And in order, or according to the governance system, the member states have to draft integrated national energy and climate plans and ECPs according to including 5 priorities: decarbonization, energy efficiency, energy security, internal energy market, and research, innovation, and competitiveness. Those plans have to include national objectives, targets, and contributions, plan policies and measures, impact assessment, etc. And they have to be subject to a public consultation mechanism, mandatory. And the draft versions have to be submitted to the European Commission. They analyze and give recommendations, and then we have that final versions that are being assessed by the European Commission and monitored by them. Another part of the European effort is the energy efficiency, where we have a recast on the Energy Efficiency Directive pending. They want to set joint annual energy efficiency targets and obligations of the member states to define national targets. They want to alleviate energy poverty and empower consumers. Public sector should be leading on energy efficiency. For example, public buildings should reach energy efficiency even faster. They have mandatory energy savings obligations, metering and billing information for consumers, information and awareness raising. They are focusing on energy efficiency, on efficiency in energy supply, etc. And another part is very important part is LULUCF, land use change and forestry regulation. Central to that regulation is the no debit rule. That means emissions from land use and forestry must be compensated by an equivalent removal of CO2 within the sector. So we have a balancing here that has to take place. And as you can see here in the graphic, forest acts as a removal for CO2 emissions, while when we use land, for example, as cropland, settlement, grassland, etc., we have a rising of emissions here. So there we have to achieve a balance. And now with the recast of that regulation, we will include binding targets for member states for increased net GHG removals in a two-phase approach. That is, until 2025, we have the obligation mainly to balance emissions and removals, and starting from 2026, new EU level targets, and that should contribute to a removal of 310 million tons of CO2 equivalents within the European Union. Yeah, as I mentioned, with progress comes new challenges, and the EU has been facing some of these challenges in the recent months and years. Especially, I can only highlight a few of them here, but especially stemming from the expansion of renewable energies and also getting away from Russian natural gas. One of that is the question of use of biomass without deforestation and land use changes. That is, how can we draw on biomass as a source of renewable energy without causing land use changes and deforestation, which would of course counteract all those positive effects of using biomass. At the same time, how can we accelerate renewable energy expansion while ensuring that nature protection, species protection will not be overruled? And last one, a very recent important question, with an increase in LNG transport, that is liquefied natural gas. So we now use much more liquefied natural gas coming or transported by ships, not by pipelines. As well as abandoned gas wells and underground coal mines, we have a rise in methane emissions, and these methane emissions are not tackled by any legislation at the EU level for now. So that's a huge problem. We are only starting to get to regulate these methane emissions from the energy sector. But first, let me come to renewable energy. The revision of the Renewable Energies Directive of the European Union proposes for a cascading use of biomass. That means we can only draw on wood-based products, for example, if we have first used or made sure that the certain biomass is not we cannot use them for wood-based products, we cannot extend their service life, not reuse, recycled. Bioenergy is only the last option before we get to disposal. So we can only use waste wood for bioenergy that could not be recycled, not reused, not extended in the service lifetime, not be used for other wood-based products. Apart from that, the revision asks for mainstreaming of renewable energy in buildings, also facilitate system integration of renewable energies, renewable electricity, for example, grid connection, and also mainstreaming renewable energy, especially in the industry sector. Yeah, the revision is currently pending. They had reached a political consensus, which was like cast aside at the last minute. So the revision is still pending, but that's what it will hopefully look like in the future. As I mentioned, the Repower EU program was a program in reaction to the energy crisis and the war in Ukraine. It was meant to accelerate the expansion of renewable energies, implement increased energy saving targets, and diversify energy supplies. So that is to get away from Russian natural gas. And the achievement, it was passed in May 2022, and the achievement was a 20% reduction in energy demand throughout the European Union, 80% of Russian pipeline gas replaced in less than 8 months, and 39% of electricity coming from renewables. So already some success. And recently, last December, they also passed the temporary emergency regulation, where they set a presumption for an overriding public interest for renewables. When accelerating, when expanding renewables, you have to make sure that you have a balancing decision between different interests that are affected by that project. And there we have a presumption of an overriding interest for renewables. Also faster permit procedures for solar energy and grid connection of smaller heat pumps, for example, and a streamlining of permit procedures for repowering, that is implementing better technologies, more efficient technologies in renewable energy facilities. In that emergency regulation, it was the question, how can we address species protection? And there it says we want to accelerate renewable energy expansions, but all those exemptions shall only apply if and to the extent that appropriate species conservation measures are undertaken and sufficient financial resources as well as areas are made available for that purpose. So renewable energy expansion, yes, but still we want to make sure that species conservation is addressed at the same time. And the last one for now, as I mentioned, the methane emissions in the energy sector. There we have a proposal for a regulation on methane emissions reduction in the energy sector, also stemming on the global methane pledge, where the goal is to reduce methane emissions that are currently not even monitored in the energy sector. So first step, of course, monitoring, reporting, verification for all energy-related methane emissions. These emissions occur, for example, when you have a leak in a pipeline, but also when you transport liquefied natural gas on a ship. It's cooled down, and you constantly have to release a bit of those methane in order to make sure that the whole system is still in balance. This is called venting and flaring. And those mitigation obligations under the regulation include leak detection, repair of leaks, and limits to venting and flaring, like only if it's really necessary. Also a monitoring and plugging of inactive wells, that is wells of natural gas that are not being used anymore. Also underground coal mines, which are abandoned, they have to be monitored because there are still emissions from those mines, for example, and they should be plugged and monitored to make sure that we do not have any methane emissions from these mines, for example. And also because that's, of course, not a problem only in the European Union, that regulation has a global perspective and takes into account import and export, for example, through a methane transparency database. So to make sure that all or related energy-related import and exports are also assessed for methane emissions within that sector. Yeah, last but not least, also important and often overseen, the EU adaptation strategy. So the EU does not only focus on mitigation, but also adaptation. It has set an adaptation strategy in 2021, which focuses on smarter, faster, and more systemic adaptation, including a more and better data on climate-related risks and losses. And we established the European Platform for Adaptation Knowledge. You can see the logo here, Climate Adapt. Also faster adaptation, that is developing and rolling out of adaptation solutions now, so to accelerate that development, and to mainstream climate resilience considerations in all relevant policy fields is also a goal of that strategy. Well, that was a short overlook over all those EU measures on climate change, climate mitigation, and adaptation. Yes, and I'm happy to discuss everything with you afterwards in the question and answer section. Thank you for now.
Thank you so much, Dr. Hofer, for providing a very succinct overview of everything that we can consider within the EU climate policy and climate strategies. As you said, if we went in detail into everything that was provided by the EU, we would be here all day, if not all day, all week. So thank you for taking on the task of providing a really good summary of the key perspectives within the EU climate measures. Before we continue into the question and answer session, I'm just going to give a brief summary of each of our previous presenters' key points, just so that we can all put into perspective what we've learned in the first 3 lessons, and then we can move on to the question and answer session. While I'm giving the summary, please feel free to write any questions in the chat, any comments that you would like to put forward. You are more than welcome to do that as well, or you can raise your hand and we can engage with you personally when having a raised hand and unmuting yourself and maybe even turning on your video so that we can see you. So firstly, we had a presentation from Professor Kameri-Mbote, who presented on the climate challenge dimension of human rights, due diligence, and state positive obligations. She first broke down the role of the Paris Agreement in interpreting human rights, firstly by identifying what climate change is and what the urgency of climate change is. So she said that climate change would lead to a world that is hotter, wetter, and wilder, and immensely different to the world we know, using examples such as drought or pressure to the ecological system. She mentioned the IPCC reports and the in which they distinctly mentioned the extent to which current and future generations will experience a hotter world will depend on the changes we make now, indicating the urgency of the need for action. She then went into a further detailed discussion on the Paris Agreement and its obligations with regards to climate change at an international level, namely the safety threshold of holding global temperatures well below 2 degrees Celsius while pursuing efforts to keep global temperatures below 1.5 degrees Celsius. This is known as the global consensus up to date. Although it should be said that the agreement does not contain everything, she referenced and said that the Paris Agreement is not a silver bullet, as in it doesn't contain all of the measures and overviews of every single area that should be addressed with climate change. One of those areas that is often missed within the Paris Agreement is the extent of human rights considerations. As she said, human rights are mentioned in the preamble, but there's no distinct section within the Paris Agreement that deals with human rights. She then went on to mention how human rights treaties should be interpreted in light of the Paris Agreement and what this means in great detail. More specifically, what does this mean in the interpretation of the standard of care of the Paris Agreement in terms of human rights? She then went on to speak about the obligations, so mainly the obligations regarding global peaking in terms of our understanding of climate neutrality or the net zero target. She looked at the perspectives on the targets of the 2030, as well as the 2050 targets and the goal for net negatives. And specifically how human rights are used to fight, human rights are used especially in the rights to private life or the rights to life being examples of specific human rights that have been used to promote climate protection. Ultimately, she addressed that in order for states to comply with positive obligations, they must take all adequate measures aligned with global goals and with human rights treaties and measures. Secondly, we had a presentation from Ms. Aditi Shaite, who provided an overview of the law as a tool for youth climate activism. We had a very in-depth discussion about how youth engagement is a key plays a key role in climate change, and specifically how there are a number of international organizations which promote youth engagement. She went through some of the lessons that we have faced when dealing with youth engagement in climate litigation, more specifically that efforts need to be made, and these efforts need to be strategically constructed. Secondly, when lobbying at a UN level, there must be a way to engage massive support from civil society, and that there needs to be an effort to provide a progressive opinion, but also one that looks backward. If we look at the phases that she mentioned, some of which being the mobilization of support or meaningful participation. Additionally, she mentioned how we can use the law as a tool for youth climate activism, more specifically looking at the Youth Climate Justice Handbook, as well as accessibility criteria. And she concluded with, how do we get there? Firstly, by engaging an army of lawyers. Secondly, by making sure that what is happening is in conjunction with UNFCCC processes. And thirdly, with ensuring that once all the aims come out, there's a large chance that this can be used in domestic and regional litigation. So not only at an international level, but how this filters down from the international to the regional and ultimately to the national. Lastly, we had a presentation from Dr. Kameri-Mbote about the EU climate crisis measures. She provided a brief overview of the EU's contribution to achieving climate targets, more specifically the EU and the Paris Agreement, and the fact of the EU-wide NDCs and the movement of the increased NDCs from 40% to 55%. So we see a 15% increase in commitments made at the EU-wide NDCs. Then she spoke about the multi-level system of climate governance, its structures and principles, and went specifically into the shortcomings of the Austrian climate policy. She then provided the recent highlights of the EU climate action between 2019, starting with the European Union Green Deal, and all the way to May 2022 with Repower EU. She looked at the EU's climate targets, which have ultimately increased over the years, as well as finally providing an overview of some of the EU's measures to reach the 2030 targets, namely the EU ETS, energy efficiency at large, the Repower EU strategy, and the EU adaptation strategy. So in the first half of today's session, we've heard a lot of varying topics, a lot of very interesting, insightful perspectives on different elements of what is today's topic, namely climate change and international law in times of global crisis. We can all agree that climate change is in fact a global crisis, and hearing these varied perspectives helps us to put into perspective what we will be going into greater detail in the next stages of the workshop, but also a little bit later today with our PhD presentation. So firstly, I will open the floor to Assistant Professor Renate Piersner-Ebner, who is from the University of Graz and also a colleague at the Research Center for Climate Law. I believe you have a question, Renate. You are muted.
Do you hear me?
Yes, we can hear you.
Okay, perfect. So thank you, Larissa. I have a question to Dr. Hofer. Miriam, thank you for the very interesting presentation. My question is related to the acceleration regulation to 2022, the emergency regulation you mentioned. That was a part of the repowering plan from the European Union. And that's a very interesting regulation because the content it includes very strict limitations for the permit granting procedures, and they are around 1 to 6 months, and it's very short. And you already mentioned the instrument from the overriding interest that would be very good to accelerate permit granting procedures. Or the other thing is that the exemptions from the environmental impact assessment regulation from the European Union. So there are many instruments, but on the other hand, we have a limitation from this regulation. It's limited to June 2024. So there is not really much time to implement it. And so my question is, if we consider that, and we consider that the authorities don't have very good personnel staff for this permit granting procedures, so they don't have enough people to work with that and to make this procedure. So do you think, Miriam, will this regulation really be successful, or is the next change the Renewable Energy Directive? But we have problems in this area either because France didn't agree to the trilogue package. So what do you think about that?
Shall I answer directly, or are we collecting questions? Okay. Thank you, Renate, for that question. It's a very good question because that emergency regulation has been viewed with, or has been expected with a lot of positive ideas on how we could accelerate that these procedures, but I'm not sure whether the regulation really can sufficiently contribute to that. And you mentioned those really strict deadlines, like 6 months, 3 months, even shorter ones for different kinds of renewable energies. I think the problem behind that is that it sets limits, but it does not, at least not for all those stages, ease what the authority has to assess within the procedure. So that's the real problem. So they have to stick to a strict time frame, but still they have to address all those challenges. Even though, for example, we do not have a species assessment, or we do not have a full environmental impact assessment, we need to make sure all the way that we still receive that level of species protection. So it does include some some time frames without really lowering what the authority has to do, and this is one of the problems. The other problems is that we have so much more problems to face in these procedures. That is, first of all, the applicants have to complete all their documentation. And still that takes a lot of time, because you have to have those reviewers, you have to have the evaluators that evaluate all those different aspects of environmental impact assessment all the way. You have even those lawyers have to be available. Now when I talk to lawyers, they have like dozens of wind parks, etc. on their table. So there's also limits to that. And of course, the availability of the technology, of the products, of the people who build that windmill. So permit procedures is one aspect. We have to make sure that this is done more quickly in the future, but it's only one of multi-functional problem here. And we have so many different aspects. And what we still have to consider here, it's only looking at the authority permit procedure, but not at the following process in administrative courts, etc. So it's a good first step, but not more, would be my overall overall assessment of that regulation. Yeah.
Yes. Thank you very much.
Carlotta, I believe you also had a question. Over to you.
Yeah, thank you. Yeah, I also have a question to Miriam. You mentioned sorry about the noise. You mentioned the climate law and the new target. I don't remember if you mentioned the effort sharing also regulation now that distributes emission among different states, which is something also quite new, right? And I was just having a look now at the targets, and they seem to be, of course, more ambitious than the one we had before, but not as ambitious, for example, as the one that claimants are proposing in climate change litigation. Also, like, you know, that think tanks propose as the adequate fair share to achieve the 1.5 objective. So, I mean, I understand that they work well as a floor and that we will have legally binding instruments when states don't comply with them. But my question is if you see them as a potential obstacles to enhancing climate change mitigation in Europe, so that states could defend themselves saying, okay, maybe this is not a fair share, but we are doing exactly what the European Union requires us. And what do you think this could be, you know, like, how do you see, how do you see legal development of this kind of issue?
Thank you, Carlotta. Yes, that's a very important point that, of course, those targets of the member states, of the individual member states, make sure that under the effort sharing decision, make sure that we reach the overall EU NDC of minus 55%. But it's not said that this minus 55% are in line with the Paris targets. So from a pure formal legal perspective, that's only a minimum requirement. So it's at least, and each member state is free to implement more ambitious targets, is also free to implement more ambitious goals and measures. But of course, that's a point. At least we have this EU regulation, and chances are high that courts will stick to that, to these limits. On the other hand, it's at least something. So we have at least binding targets for all member states, even if they, in their national framework, couldn't reach any political consensus on any targets, like in Austria. So it's certainly not not perfect, and certainly not what we need to achieve that 1.5 degrees. Also looking at the scientific evidence available, so it's not enough. As I mentioned, the European Parliament even asked for an increase of those minus 55% when it was just passed. But still, it's a starting point, and it's a legally binding and sanctional starting point. So I think so it's positive from that side. On the other hand, what I couldn't mention in my presentation was that the EU has, when it comes to certain measures, also some negative impact on member states that would aim to have more ambitious policy measures. For example, when you mentioned the discussion concerning the ban on fossil fuel cars in 2035, first of all, member states are not free to implement such a ban, for example, earlier due to EU law. And also now we have that agreement on alternative e-fuels. And if we have that European agreement, a member state is not free to choose not in our state. So you can think about e-fuels, whatever you want, but still, if you have that European consensus, a member state cannot just say not in my state. So if that's not a positive development for climate action, that's something that sticks and is mandatory for each and every state. So that's a significant negative perspective of EU law here. Thank you.
Thank you.
Thank you so much, Miriam, for the answers to those questions. I have another question for Aditi, actually. The question says, within your presentation, you mentioned that there are levels of participation and engagement. What exactly does this participation look like, and how do we ensure that engagement reaches the most vulnerable and poor communities?
Thank you so much, Larissa. I mentioned participation in the way that law could be used as a tool. So one most important point would be that we, as youth organizations or as young lawyers who work in the field of climate law generally or environment law generally, we make sure to participate in proceedings that call for engagement, like the OHRCR call for intergenerational equity. It would be submitting answers to that would be one way of participating meaningfully. Another point that I mentioned was also the written submissions for the Inter-American Code AO that we are doing. So I think that also ensures that we are there is some sort of participation from youth engagement, and we try to do this in partnership with other civil society, grassroots level NGOs based in Latin America for that. So as I mentioned, there are like two phases of it. One would be in Spanish, which would be accessible and not just to Spanish speaking and like the community in general, but for them to also engage in the process and make sure their submissions, their answers are put forward to the questions asked in the Inter-American AO resolution. So these could be one of many ways of participating. And then definitely one most important way would be trying to build capacity, and that is something that we try to do as much as possible. But again, it really depends on a lot of resources that are available, that we want to engage with indigenous groups, communities, women generally. So bringing them to the table, making them understand that this is something that they could participate in, this is how they should do it, that would go into building this sort of capacity and engaging with them. So I think those kind of activities are something that WICJ generally does. But apart from that, also we call for submissions to create literature generally on our website, as blogs, as participating, conferences like this, making writing as much as possible building legal literature as much as possible for certain arguments. That is another way of, I think, using law generally as a tool to participate in these processes. And it definitely, I should mention this because it does become very difficult. It is quite challenging actually to get a lot of participation from the most vulnerable communities and indigenous groups. It's because of all these sort of resources, but at the same time, I think it is important to also note that the work that we're doing, especially these AOs that we're campaigning for, are, first of all, they're coming from most climate vulnerable states that are leading them. The support that we've got are from developing states. So another important aspect of that in the ICJO procedure is that we try to mobilize as many developing states as possible at that level. So while we are trying to mobilize civil society, we're also trying to make sure that the civil society is impacting this developing state government or decision-making bodies to participate in the higher level of engagement, like the AO, and making written submissions for those states. So these are few of many activities that we try to push towards making engagement and participation as open as possible. Yeah.
With that being said, there's another question for you, Aditi. How can those listening today become more engaged with WYCJ? Is there a way, a platform, a project, or something that you would like to maybe engage with and tell us a little bit about, so that we, or those listening and those attending, can also engage with the work that you're doing?
Oh, definitely. Thank you so much. Yes, you could just go on to our website. I'll put it in the chat at the end of this for everyone. And you can just write to hi@wy4cj.org. And most of my work generally with WYCJ is making sure that there's legal engagement and dissemination of the handbook, and making sure there is as much literature possible around the handbook. So we accept blogs, we accept collaborations with other organizations, workshops, webinars, whatever is within our capacity and whatever is possible. That would be great. And for those based in Latin America especially, but also otherwise, who would like to engage in the written submissions for the Inter-American Court AO, yes, please feel free to write to Carlota or even me, or just WYCJ and generally, and we could take it forward, because as I said, we want to work with civil society and grassroots organizations in Latin America. I think we're working, organizations I think we're working with is Sahil and another one. I'm not sure. I think it's AIDA or maybe Clima del Ruta, and I think we are open to even more suggestions, because we want to make it as open and participatory as possible. So, thanks, Larissa.
No problem. Thanks so much, Aditi. And yeah, for those that had asked that question, Aditi will place the link to the WYCJ website in the chat for you to look through. I have one final question for Dr. Hofer. The question was, it is clear from the multi-governance system that there is a possibility that EU countries can fall behind the veil of the EU NDC, meaning that especially in the context of the Austrian example that you gave, sometimes EU countries may not have their own targets, their own responsibilities, and as such may fall under the auspice of the EU. Do you think that if there was no such multi-level governance functions, that there would be a greater chance of us achieving the NDC, of achieving the climate targets that have been set out by the EU? Or is it because of this multi-level governance that there is more responsibility placed and there is an oversight body, so to say, that encourages change at the national level? Over to you.
Yeah, thank you so much for that interesting question. I actually think that climate change and the climate protection measures are something that must be undertaken and also planned and envisioned by the individual state. it's not something that could be fully covered from the European Union due to the different situations, policy, overall policy understandings in the individual member states. So I think a European Union that would settle down every single measure for climate protection for each member state as in the same way, that just wouldn't wouldn't make sure that it just wouldn't fit for all those different member states. They have, for example, completely different approaches to renewable energies. While France and Poland, etc., they want to draw on nuclear power. Austria, for example, has banned all nuclear power within Austria since quite a few years. So I think that just wouldn't be possible. And given that situation, that we need each and every member state to define its own climate policy and climate protection measures, I think the multi-level governance system is valuable and can ensure that even if a policy, if a political system within one member state does not ensure that we stick to the Paris Agreement targets, the multi-level system, including the EU, can make sure that every member state at least sticks to the EU targets here, and impose also sanctions. And I think that's something that is also reflected in the Austrian media and the political discourse, that if we do not reach those targets, even if we do not have targets implemented in our national law, if we do not stick to the EU target, it will be really, really expensive for Austria, because all those sanctions also include monetary sanctions. So that is something that is envisioned also in a state that has no own climate targets here. And that is something which is like, even when it comes to money, it always gets problematic. So I think Austria, also as a state that has no own climate targets for now, will make sure to stick to the EU targets. And this is where the multi-level system, including the EU level, has significant advantages over a system where we would only have the member states and the Paris Agreement as a global system, but with no sanctions, no binding effect, etc.
Thank you so much, Miriam, for that. We have one final question for you. It's more a remark, so to say. If possible, would you be able to provide some links in the chat to any of your recent publications? I have someone in the audience who's really interested in this presentation that you've given and wanted to know if you have any more specific or nuanced presentations on EU climate in general, or the Austrian perspective with climate policies. They'd be interested to do some research, but I will also put you in contact with that person. So if you have any publications that you've written or anything that you feel would be interesting in supplement to this presentation, please feel free to put that in the chat for the audience to engage with.
Yeah, you can of course get the presentation. The problem with publications is that most of my publications are in German. So I can of course provide them, but they will probably not be of much use for most of all. But yeah, please feel free to get in contact with me. I think via email, that's most probably the easiest, and then I will just get you forward those publications to you. Thank you.
Perfect. Thank you so much. If there are no further questions, I would like to open the floor to questions from the audience. If anybody else has any other questions or any comments they would like to make, now is the time. If not, we'd probably go to our coffee break a little bit earlier than expected. We had planned to have a coffee break from 15:20 to 15:30 to allow everybody some time to stretch their legs and get that cup of coffee in, maybe grab the bite to eat that you missed during the lunch break. It's been a great first start to the day, a great lecture session. I think we've learned a lot and we've engaged a lot with one another. And we look forward to the PhD candidate session, which would take place after the break. So until then, thank you so much for joining us. And thank you once again to the presenters and the speakers for giving such an insightful start to this workshop and a great perspective, not only from the international side, looking at human rights in the Paris Agreement, but also specifically to youth activism, which a lot of us can relate to on a personal level. And lastly, to look more closely at the EU's climate crisis measures and the perspective from the European Union. So I'd like to thank the presenters once again, and I will see you all at 15:30 promptly to begin our PhD candidate session. Thank you. Well, welcome back, everyone. I hope that you've all managed to have a little bit of a walk around and have some time away from the computer. Thank you for joining us for the first half of today's session, and thank you for staying for the second half, which is the PhD candidate presentations. We are to have two presenters today. Unfortunately, our first presenter has yet to join us. So I will hand over to our second presenter, who is Letitia Maria Lima. Letitia, are you with us? Hello, Letitia, can you hear me?
Hello, can you hear me?
Yes, hi, we can hear you. I know we were only supposed to have you present a little bit later, but we're still waiting for our first presenter. So would it be possible for you to present now?
Of course. Sorry
Great.
for the delay.
No problem. Welcome to our PhD workshop. As I said, this is Letitia Maria Lima. She is a doctoral candidate at the Pontifical Catholic University of Rio de Janeiro and an exchange doctoral candidate at Humboldt University of Berlin in Germany. In addition to that, Letitia is a lecturer at the post-grad course in Brazilian environmental law and a co-founder of the research group on law, environment, and justice in the Anthropocene. We look forward to hearing about your presentation today titled Women, Climate Justice, and Intersectionality from the Global South to the Global North. Over to you, Letitia. Thank you.
Thank you very much, Larissa. Greetings to everyone. It is a joy and an honor to be here today. First of all, I would like to thank the organizing committee of the event and for the presence of everyone here, and especially to my advisor, Professor Danielle. I believe she's also here with us. So first of all, I would like to introduce myself as a researcher from the Global South. I am Brazilian, and my life experience has been in the Global South, specifically in the state of Rio de Janeiro, in the southeast of Brazil, where I was born. And I am from the Atlantic rainforest biome, which I learned from an indigenous woman called Shirley Krenak. It's an important information to give when we are talking about where we are from, because in Brazil we have different types of forests, not only the Amazon forest. So my academic path has always been with environmental law. In 2018, I co-founded, together with my professor Danielle, the research group Law, Environment, and Justice in the Anthropocene, also known as JUMA, at the Pontifical Catholic University of Rio. And in that time, in 2018, we began to delve into issues of climate justice, among other things. And at that moment, I was in my master's program. And as soon as I started to understand the climate justice movement better, I realized that there was a need to expand its logic beyond the environmental justice movement, which began in the 1980s, and was an extremely important movement that made possible the union of environmental demands and civil rights demands of Black and Latino populations that were being disproportionately affected by hazardous waste facilities in the US. And this was a defining moment in the history of environmental movement, because for the first time, the environmental issue began to be understood as intrinsically connected with social demands. So the climate justice movement is part of the environmental justice movements, but with a specific focus on the climate crisis. And this is decisive for the discussion about climate, not only to remain not only to get out of the realm of physical and chemical and biological data about climate, but to demonstrate that there are demands for justice, and not only demands, but historical and social reasons for this global crisis, in which the most affected are populations that have least caused the problem. So climate justice is a movement which began in the 1990s and has been gradually growing and gaining more and more space in the international climate discussions. And one of its main focuses is the historical responsibility of countries and companies of the global north for most of the historical emissions of greenhouse gases since the Industrial Revolution, and more intensely since the Great Acceleration in the 1950s. So, for example, the United States and the European Union account for 27 and 22% respectively of the cumulative historical emissions from fossil fuel combustion and cement production, while some countries of the global south, which have contributed little or nothing to the increase of the planet's temperature, bear 90% of economic losses, 98% of affected people, and they suffer 99% of the deaths related to climate change. So climate justice is slowly gaining traction in the international discussions. And it was only in 2015 with the Paris Agreement that was also discussed that the term climate justice became a part of the goals and considerations of the COP in the UNFCCC. So in my research, the understanding of climate justice and its historical responsibility and its main references, especially from the global north, are all important points to understand where we start from in this discussion, but also points to where we should go with this discussion. So I started to realize that some points needed more visibility so that the most impacted people and populations could effectively have some chance not only to speak, but also to survive this process that, although affects the entire population of the planet, we know that, but has much more serious impacts on Black and Indigenous women from the global South. And that is my focus in the research. So I try to understand climate justice through a feminist intersectional methodology, mainly through the axis of gender, race, and positionality from the global South. And I understand that climate change should be analyzed from this perspective, this feminist perspective, because all over the world, women are on average poorer and less educated than men, representing 70% of the total number of people in extreme poverty. And therefore, being the most affected by the harmful events of climate change, such as landslides, floods, hurricanes, and so on. So the next step for me now in the doctorate research is not only to update and understand all this body of knowledge built mainly by authors and international organizations from the global north, but also to make an effort to seek authors from the global south, and also to contribute myself to this concept to be thought and disseminated as democratically as possible. And this means including the most impacted populations in all spheres of discussion, in the knowledge production and in actions against the climate crisis. This means not only getting to know academic production from the global north and the global south, but also experiencing the climate movement itself in these two different dimensions. So that's why I'm at the Humboldt University in Berlin right now as a visiting researcher, precisely to experience these issues that I discussed in my thesis in these different realities. So speaking about an example taken from the Brazilian reality, last year, I participated as an organizer of a collective publication that serves as an input to this effort that I'm proposing here to listen to the Global South. It is a book called Who Needs Climate Justice in Brazil by Observatório do Clima, Climate Observatory of Brazil. where we interviewed Black women, rural women, women from traditional communities, indigenous women, and so on, from all regions of Brazil. And this publication helped to start this production of knowledge from the Global South, and demonstrated to us in Brazil how much the discussion about climate justice still needs to move forward, not only to reach these women, but also so that they have the space and the agency to say what they think about climate justice, but also to show us what solutions they already have for several of the issues involving climate change and climate justice demands. So it may seem a little obvious to us to talk about listening to the most affected people, but in practice, this is not what happens. And many times the solutions that come from outside and have even more impacts to these women. For example, there is an impact of the construction of wind power generation lines that cut across traditional communities in the northeast and north of Brazil, and that leave traces of sexual and gender violence for those local women and girls. And this is only one of the many examples of gender impacts that are not thought through in the process of applying climate solutions, especially in the Global South. So what the research aims to demonstrate is that understanding climate justice movements involves a cross-cutting range of analysis and theoretical lenses that have not yet been sufficiently analyzed, especially from the point of view of women as both agents of the change and also as the main people affected by the climate crisis. And it is at the confluence, I think, of these theories and empirical analysis that my research proposal seeks to deepen and make explicit the connections and the asymmetries between climate justice movements from the Global North and the Global South. The objective of the research is to review and develop the concept of climate justice within this new context that imposes on law urgent and adequate responses to solve environmental and climate inequities that are unfairly disproportionate, because despite the global climate crisis being indivisible, they are aggravated by the unequal distribution of burdens and bonuses among countries and social groups. So it is an ongoing research, of course. It's at the middle. And I am open to comments and suggestions for approaches to tie all these perspectives together and to help climate justice to be as effective as possible. So thank you very much for listening, and I'm here for the discussions.
Thank you so much, Patricia, for your presentation. I think that your topic is really relevant, especially just thinking about myself and my own situation, as well as my colleague Carlotta. We're both obviously women, and we both have quite a connection to the Global South. Me personally being from South Africa, the Global South, and seeing the implications of climate change on women and vulnerable communities. Personally, I know that this topic is definitely needed, and I really do commend you for taking on the task. And also with Carlotta, just having completed a research stay in Brazil, where she had also seen perspectives on climate litigation from the Global South perspective within Latin America. So I think for us too, if I can speak on her behalf shortly, this is definitely a topic that we engage with, and a topic that I think we feel too personally, not just in an academic sense, but also in the sense of lived experiences that we ourselves have seen. I have some questions and comments, but what I'm going to do first is hand over to Carlotta and then open the floor a little bit after that. Over to you, Carlotta.
Sorry for cutting over the people who send questions. Actually, I would also encourage everybody to raise their hands if they want to engage directly with the speaker, so it's more interactive and fun. And so nice to meet you, Leticia. I didn't have the chance to meet you in Rio, but maybe, as you know, I collaborated with your supervisor also in the Juma there. It's great to hear about your work today. I think we have a very similar interest in the movement's perspective. I'm focusing in the movements that are also committed with climate litigation, but I mean, oftentimes these movements are doing more things than that. So my question would be, what kind of methodology are you using when you say experiencing the climate movement? Is it interviews? Is it rather ethnography? What kind of movements also are you looking at, or are you working with, experiencing in Europe? I imagine that they will be different from the ones in Brazil. Obviously, I don't think that there is an indigenous movement in Germany. And if you already have some insights now from this research that you think you would like to share today, so for example, something that movements in Europe or elsewhere in the global north learn from movement in Brazil, where indeed the environmental justice was born in the 1990s, and where maybe it has been a more democratic movement than it has been in Europe for a longer time. So if you have some observations on that.
Thank you, Carlota. I'm sorry you didn't have the chance to meet in Rio, but talking about the research, the methodology, just to position myself in the research, I am still in the beginning, middle. So I am starting to reckon all the methodology that I will be going to use, but interviews are going to be part of the research. I intend to interview the movements here, and I already started to get to know some of them, and especially some refugee movements, because what I started to perceive is that most movements from the youth here, they are they don't necessarily have the perspectives of intersectionality and the global south and all this historical responsibility that I approach in my research. So I found that the refugee movements here are very intense, and they talk about these issues, and it's been an interesting reality to get to know it. They are very different. The movements are very different here, but I haven't started yet to interview them. And this is being here for me is very important to not only to present the research, but also to listen from you that are here already and already have some experience with the field and with the movements. It's very important to me to get to know what I could gain from it and learn from it. So the methodology, it's going to be, first of all, intersectional methodology, but the interviews have not yet been defined how they are going to be. But I've already started to look the movements and to talk to some of the leaders, if I can say so. So the movements are really different from the ones in Brazil that I have the chance to know, especially because in Brazil we have a very strong indigenous movements and quilombola movements. There are traditional Black communities there, and from what I have already noticed, they are different because of the different realities, obviously, but also I think over there we have a climate justice perspective more grounded on the race agenda, on the indigenous agenda, and all of those territorial difficulties and debates that we have in Brazil. So this is very interesting to know. But here among the refugees, I found very similar discussions. So that was interesting to me. And I think from you, the last question you asked was about some insight. And I've been in Berlin for not so long, so I think the insights that I have gained is that the discussions about historical responsibilities and the solutions there most of the time imported to countries of the global south, they are not being that well addressed, I think. I hear a lot about talking about these different realities, but not listening that much what they have to say. And I think the solutions, they have to come from the women and the traditional communities from the Global South, because they really know what's going on. So the example that I gave you, when I interviewed this women from Bahia in Brazil, she said to me that the solutions that they brought more gender problems and more sexual abuse than solutions, because those communities didn't live that much in the problem, and they began to live the problem after some solutions were imported. So we have to have solutions for this crisis coming from all over, but we have to listen to the people that are going to be affected in the territories for how this should be applied. Of course, we have to have wind power lines, but we have to know how they're going to be applied and the populations that are going to be impacted. So I think the most insightful thing was to learn the wisdom from these women, and not only their wisdom, but their solutions. They have solutions, they have knowledge that we have to really listen, and not only listening, but give agency to those women so that they can do what they know how to do. So I think it's that. Thank you.
Thank you so much, Patricia, for your answer and for engaging in this content. Before I pose my questions and my comments, I see a few of the PhD candidates are also still present and attending the workshop. So if there are any points that Patricia has mentioned or anything that Carlotta and I have said that you resonate with, please feel free to engage with us. Switch your camera on, and we can have an open discussion about things. I think if we can bounce off each other and kind of support each other in the discussion, that would be really great, not only for Patricia but for each of us that are still in the PhD process. So Patricia, my questions for you is, I'm going to ask them one by one, and then maybe if when you answer one question, you'll answer the next one. So firstly, the topic that you've chosen, obviously, in the relations to the gender and race dynamics in relation to climate justice and intersectionality, those are very big topics independently. And the correlation between each of these topics, especially in the research field, with the niche of the triad that you're talking about of gender, climate justice, and intersectionality, is sometimes, or more extensively, not researched. So in that specific dynamic, which is obviously something new that your research is bringing about. But I would say that in your research, there must be rather extensive academic papers, maybe not necessarily academic in that sense either, but research done in the field of gender and climate, or climate justice independently, or global South and global North perspectives on climate injustice. How have you found a way to narrow down your research so as not to be overflowed with all of these different varied topics coming together as one? So that's the first. I don't know if you want to answer that first.
That's actually a great question, because it was a problem that I encountered when I first started to study this. But when I started to research climate justice, for me, it was becoming more and more obvious that the issues for women, and especially Black women and Indigenous women, had to be addressed more specifically. So it was like the movement was talking about a lot of things, but not talking to some points that I've encountered and some data that I've encountered that I thought that I should talk about. And then I had to bring together these three big concepts that you mentioned. Like, I had to bring together intersectionality, because for me, it was the best methodology to understand what I was reading about. So, as you said, I had the feminist and the environmental data, and I had all the climate specific data. And as I was reading about it, some documents mentioned them together, like gender and the climate crisis, but not so much race. And I was encountering some gaps that I really felt that I needed to fill, and at least try to fill. And for me, it was not possible to talk about climate justice without addressing the gender and the race and all the other axes of oppression that the intersectional methodology shows us. It was impossible not to see that and to start and to continue talking about climate justice from a wide perspective and from a global north perspective. That all of those perspectives are very important, but I believe that for the climate justice to be really effective to address the people that are going to be most impacted, I could not run away from the race and the gender issues. So it was difficult to bring together all those three, especially because it has a big range of documents, and I had to collect and understand them, as this was a while ago, and now we have even more documents about that. We have, I believe that since I've started researching these three themes together, the number of documents talking about race, gender, and climate has increased a lot. And I'm very happy for that. And in Brazil, for example, that publication that I mentioned, I was very happy to be able to participate, because it was my chance to talk to those women and to get to know what I was academically thinking about, but not on the field researching. So it was a very important experience for me. So I'm still in the process, that's the thing. And I think my next step is going to be like really diving in the movements and understanding the asymmetries between them and the connections as well, because there are a lot of connections from the movements here in the North. There are a lot of people talking about this gender and race and colonialist things. So I'm very happy to see that, but I think we have a long way ahead of us. We still have a lot of work to do, and I'm very happy to be able to be here in Berlin, because if I stayed in Brazil to do this research, maybe I would not have all the perspectives that I'm gaining here to unite those two perspectives and to try and help to write about climate justice from a very complete and more effective point of view. So sorry if I took too long to...
No, please, you don't have to apologize for taking too long. This session is for you, so you take your time. The next thing that I wanted to mention is, and you touched a little bit on it, especially coming from the perspective of the Global South, there is the discussions on colonialism and its impacts on climate justice and climate change, broadly speaking. So again, that is a huge topic on its own, and that warrants its own merits in terms of of research. Is that something that you are going to touch on in a perspective of your PhD, or something that you've thought of, or is it maybe a little bit too outside of the scope of your research?
Yeah, it is something that I'm going to dive in, especially the decolonial literature, because when we start to understand all these points, we see that the colonial history that we have in the Global South, it's very important to explain a lot of the processes that we have there, and to explain a lot of the responsibilities and even the types of development that we have in the South and in the North. So I think it's impossible not to talk about colonialism, and it's going to be a very important point in my research, but it's not something that I've already started. I've read some things, but it's not a point. It's a point that I really want to bring into the work, for sure.
Carlotta, do you want to ask your next question before I continue?
Sorry, unless you have questions from other people.
Not at the moment, no.
I mean, more than a question, just some questions to make you think how you could direct your research in the next years or year, I don't know. So I think research design is a very important part of the thesis, and it's really underestimated how hard it can be, especially when you're maybe a lawyer and you're using different approaches, right? You're looking more into sociology or anthropology. So I think it is really important, or at least it was really important for me to understand why I'm selecting specific case studies. And this is true also for comparative law, no? And sometimes it is uncomfortable to think about this question because we might just maybe be interested in a state, want to go for that because of some personal interest, but it's really important that there is a clear research question directing you to compare one case to another. So this could be an uncomfortable question, you know, why Brazil and Germany, if it's the German movement that you're looking into, and why not, for example, Brazil and Switzerland, I don't know, or other cases in Europe. Also, since you're talking about intersectionality, why gender and race, and why not class? And thirdly, considering that you're looking into indigenous movements in quilombolas, I know that there are indigenous movements in cities, the indigenous communities present in cities, but I imagine that you are concentrating maybe more on indigenous movements in rural areas. I don't know if you're working in the area of Rio or in the area of other states, no? Because indigenous are in every state almost in Brazil, no? I think this could be another interesting dimension when you're comparing movements in Brazil versus European countries, the rural versus urban. Because I think indeed it is true what you say, that the most impacted are also the most aware, which in Brazil translate into political action, being able to frame climate justice as an intersectional issue. In Europe, it might not be the case. Like, it might not be the case that you go into a rural community, into a Austrian rural community, and they talk about intersectionality. Probably that's not going to be the case, but they are very aware that they are more impacted. And you might find out that they are aware also of the gender dimension of it or not, which could be an interesting finding. So yeah, I think these are the questions I wanted to ask you. You don't have to answer to them now. I don't know if there is time left for it, but maybe hopefully they can help you.
Larissa, how much time do I have?
You have a lot more time than you thought. So our other PhD candidate unfortunately can't make it because she's had some emergency that she's had to deal with. So unfortunately, she won't be joining us. We are scheduled to finish the PhD workshop at 5 p.m. It is now 4 p.m. So you have an hour, but I don't think you'll be taking the whole hour. So please take as long as you need. Yeah, you don't feel pressured to feel like you have to fill the hour. If we finish earlier, we finish earlier. But yeah, this is just a platform for you to use as you will.
Okay, thank you. And it's what I thought about it. Like, I really want to listen to you as well, because I think many of you have a lot of knowledge and a lot of things to add to my research. So for me, it's very good to listen. And thank you, Carlota, for your observations, because those are some of them are things that I have thought about. And as I said, as I'm in the beginning of the research process, I have years ahead still. So the first question you asked was why Berlin and not why Germany, not Switzerland. It was for a very specific reason, because in my university we have a project called Spheres of Citizenship that it's between PUC, the Pontifical University of Rio, and Humboldt University. So it was an opportunity to come to Europe and study these movements. But I'm not, the project is focused on Rio and Berlin, but I'm not going to close this as only Berlin. I want to understand how the climate movement works here. And since I'm at the beginning, I'm still trying to understand how they work and how I'm going to approach this variety. And so that's more, the answer is more like that. And you asked about class. I didn't mention when I made my points, but class is one of the axes of oppression that come up when we are studying. So class is another way to analyze. It's another axis that, combined with the others, make those women even more marginalized and vulnerable. So as many axes of oppression that happen, they are all going to be welcome, let's say like that, because we cannot specify or differentiate the levels of oppressions that exist. Every woman has different types of oppressions and vulnerabilities, and class is a very important one for this research, because the Global South has a lot of poor people and working class people, so class is very important, and some of the literature is going to be on that as well. So what I'm trying to do has a lot of inputs from a lot of different discussions, and I think that's the challenge, to try and come up with something that unites all of that and makes sense of it. But I think that's the challenge, and I'm really passionate about this discussion, because my whole academic path was in environmental law, and when I started to understand the gender and the race and the class discussions, I couldn't ignore them from then on. So they are part of my thinking and my way of looking at the world and understanding what is happening. So class is a very important axis that I'm going to analyze as well. A point that you said that's not defined for me yet is the rural and the city movements. They are very different. And for sure, in Brazil, for example, we have like the indigenous communities more disconnected from the city movements, and it's hard to understand how I'm going to analyze all of that, because the movements in the cities are more brought by young people and from different perspectives and different types of people, and it's very important to understand how I'm going to do this. And this is a point that, if you have something to say back to me, I would like to listen, because it's very important to understand and to describe and to decide how I'm going to look at them. But the movements, they happen mostly in cities, like not the movements, but where they gather together to protest, and it's mainly in the city. So that's something I have to look and to analyze to understand how this is going to be put in the research.
Okay, great. Thanks so much, Leticia. My next question for you is, so when you submitted your abstract, you had to identify specific parts of your research or something that was specifically challenging to you. And you also stated that data collection, if let me just go over this again. The question specifically is, what problems are you encountering during your research? And one of those problems that you stated was data collection. So in short or in long, or however you see fit, could you tell us basically what your problems are facing specifically with data collection? And we can see maybe between those of us here, if we can come up with some possible solutions for you or a way forward, or maybe give you examples of to how we addressed our data collection problems, and we can take it from there.
Yeah, when I answered that question, I think all of the options were an option, because we encounter so many problems when we are trying to think and to come up with the research. And I put the data as one of the main issues, thinking about the data from the Global South being more specific and not always being so vast and so precise and so easy to encounter as the data we find from the UN documents and from other international entities. So for me, one thing that I think it's a problem, and not data specifically, but I answered like that, is, for example, the interviews. It's not data, but it's something that I have to do myself, because otherwise I won't get the answers that I need. So if I had that data already existing, so maybe it would be easier, but we have to go and to understand the problem in the territories. And I think when I answered that question as being one of the biggest problem is the disparities in data from the north and from the south. And if you have any information about how to do that, as I'm still in the process of defining how I'm going to move on with the interviews, maybe that's going to be very helpful. So that was my biggest concern. That is my biggest concern right now.
Something about that? You want to say something, Larissa?
Yeah, I do. But you can go first. I don't mind. Okay. I also had a similar challenge with data collection, specifically because my thesis is also a comparative law perspective, and I'm also looking at global north, global south comparison, but I'm specifically looking at energy access. And the issue that I had was also an issue of disparity between the definition of energy access. So what I had was in the global north, it was perceived as one thing, and in the global south, it was perceived as another. Sometimes the problem is the solution. In my case, that's what I found. So the fact that there was this disparity meant that I had to review the concept separately in 2 different regions, which is not necessarily a bad thing. I think it provides perspectives that you may not necessarily think of. With data collection, though, especially if you're reading a number of different things all at once, you can sometimes get overflowing with too much literature, too many sources, you know, and sometimes you can get bogged down with that as well, maybe finding something more niche that you're looking for. So if finding sources is the problem, I would suggest maybe breaking down your concepts into bite-sized pieces. So that can be a possible solution. But if the overflow of literature is the problem, as in finding the correlations between the gender, climate justice, and intersectionality aspect, you mentioned that you had to kind of look at those concepts separately, gender, climate change, you know, and climate justice separately, and then there was a common thread, so to say, in the literature that, you know, you could apply within your research. In that instance, I would say that the way that I've found a way to manage an overflow of information is to categorize. So when I was looking through different literature, you find one golden thread or one common idea or main idea in one source of literature. And it's never a bad thing to have too many sources. I think you get a lot of different perspectives. But when I was reading literature in the beginning, the mistake that I made was I wasn't highlighting the main idea. I was looking at what is common between all of those articles, and sometimes that is the problem, because especially if you're writing in a field like climate change, there's common statements that are made by a number of different authors. So the way that you can kind of differentiate the overflow is if you find one key concept that separates this author from the general noise that you're hearing in that field, then that is a perspective that you can use. But like Carlotta said, research design really helps here, especially when you're trying to figure out, you know, how to differentiate and separate what is general to what is specifically relevant to your thesis. So yeah, I hope that kind of provides some sort of insight. Carlotta, over to you.
Yeah, so regarding the the literature review that you were just making now, I remember that I once read an article that had a very commonsensical but still good recommendation when you have a lot of literature in front of you. When you're approaching all this literature, try to remember your specific research question, or try to make it as specific as possible, so that once you have collected all the literature, you can divide it
in different categories or in different folders. And let's say folder 1 would be the one that is really the most relevant one to answer your research question. Folder 2 is less relevant, but it is connected to a research question that is maybe very much related. The third one, it's about the I don't know, the overview of the topic or something like that, you know? So you will start reading the articles in folder 1, maybe you can start writing already, and then you go on and you read the other articles, you know, and this already gives you a structure on how to not be overwhelmed by the literature and how to make ordering chaos, basically. So another important, I think, point for me was about finding maybe an analytical framework. So it might be the case that you have authors in the global north that have come up with an analytical framework, and in the global south there is less, or vice versa. But I think once it resounds with your research and you think it's applicable to the two cases, you might just apply that one. It also might be the case that you don't find the right analytical framework before starting your interviews, but you start doing the interviews and you do maybe 3, 4 of them, and you start finding some recurring elements, let's say, or 3 people tell you the same thing, and then a 4th person tell you something very different. And you're like, okay, this is an interesting difference. Probably I want to ask this to the 5th person, what this person thought about this, or how she lived this specific experience. And so what I'm trying to tell you is, in the process of gathering data with interview, you might create your own categories, or you might make an idea, you might get an idea about what are the categories that you're finding. And at that point, you might find the right article that has come up with a good analytical framework that fits. That happened to me, for example, with a part. I was comparing also a bit movements engaged in climate litigation in South America with movements engaged in climate litigation in Europe. And I found an article about strategic litigation in Brazil that was describing 2 different ideal types. And I found that these ideal types had recurred. So I had found these 2 different ideal types in Europe as well, even though, you know, there was not an article about this regarding European cases. But also for that article to resound with me, for me to understand it, it was important that I had done some interviews, you know, that I had talked a bit with the people and that they had answered the questions. So I think it is okay to start interviewing when you don't have already a very clear analytical framework. That also will depend on the analysis method, the method of analysis that you will choose, because some are more inductive and others are more deductive. So in my case, it was inductive. Therefore, it was okay that I didn't have the categories, but you might choose one that is deductive, and therefore you might already come up with some categories and maybe change them during the process. Also, if you are just starting to read the literature about the methodology, or if you feel like you want recommendations on that, you know, for example, what kind of interviews are you doing? If you're not sure about that, or how do you want to analyze them, feel free to let us know. Me and Larissa and everybody else here, if they have good literature recommendations, we will share them with you in the chat.
I would love to hear from you more after the event, because I think we think about similar discussions, and I keep postponing starting the interviews because of this analytical framework, but it's something that I want to start doing, specifically to do so to start and understanding the categories. I had you worked with Daniele, so you know we came up with the platform for Brazilian litigation, and we had to change a lot the methodology during the initial period, because we kept encountering different kinds of ways to analyze the litigation in Brazil. So I know it's going to be a process, and it's very important to have this feedback and to talk to you guys, so we can come up with something that helps all of us. So thank you for the insights.
Leticia, we have one question in the chat. It says, how are you including in your research the issue of the guardianship of traditional ecological knowledge systems, sorry, I can't read this, by Indigenous women, and the inclusion of this aspect in climate adaptation policies in Brazil and in the Global South? If you need to read it again, the question is in the chat for everyone to see.
Thank you, Eric, for your question. I haven't included this question in my research. It's something that I have to think about it. I don't know what you mean exactly by, I understand, I think I understand what you mean about guardianship of traditional ecological knowledge, because those traditional communities, they have this knowledge, but I don't know exactly how I'm going to approach this in the research. If you have any insights to give me, I would be very pleased to listen.
Eric, I don't know if you would like to add any additional comments to that, or clarify, or if that's okay for you. If so, you can unmute yourself and put your video on, and we can chat with you directly. Until then, Leticia, do you have any specific questions that you wanted to ask us, or anything that you wanted to know from our side? I mean, Carlotta and I are both at the final stages of our PhD, so we can give you limited advice on what we've been through up until now. But yeah, if there's anything that you would like to know, or anything that you would like some insight on, we're also here for that.
I'm sure you have a lot of insights for me, because as you said, you are in the final stages. So I think most of the problems that I have encountered and I'm going to encounter, probably you already have faced. So I think methodologically speaking, and the analytical framework to move on from all the knowledge that we unite in the research, and that to start the process of writing and the process of interviewing. But you already spoke a lot about it, so I think we are going to continue this discussion afterwards. But if you have something more to say about that, I would be very glad to listen to you.
Just one more thing. I know the problem of postponing. Also, I don't know if you've done interviews before, but I hadn't done it before the PhD, so I was also anxious about it, and I postponed because of that. Consider the time of actually having the person accepting the interview. So I don't know if you are going to the movement, to the seat of the organization, then it's easier. But in my case, I had to write emails, and not everybody replies quickly. So just, you know, as a good motivation also to start the interview, maybe when you're feeling like you have a good guide, I have a good list of questions, then start writing the emails. It will take some time still until the interview is scheduled. So you will have more time to overthink it. No worries about that. Yeah, I think also like starting when you have a list of questions is a good recommendation. And they will become easier and easier the more you advance. And please, yeah, keep us updated about your work. And I hope that we will have a chance to hear about it when you have something written, when it's more advanced.
Thank you, Carlotta. I've had the experience to interview people before, so I think that will help me a little. But it's this, we have to start at some point. So, and of course, please let's reach each other after this, because I think I would love to read your work as well, and also to exchange some thoughts. Thank you very much.
Yeah, so the plan is, yeah, before I give my 2 cents worth of comments, the plan is for us to have a PhD workshop follow-up with all of the presenters from the PhD workshop and anybody else who are PhD researchers from the previous year's workshop who would like to be interested in. And usually at that follow-up, we had one for last year's PhD cohort, and we basically, it was an opportunity for us to give updates on our research, but also at different stages in your research, you have different challenges or you need different, kind of feedback at different stages. And so we have that, a relationship with the previous PhD candidates. So we're going to continue with that this year, and you'll be introduced to some other PhD candidates who may have just recently finished or are also in their final stages or are also just beginning. So that is going to be an opportunity open for everyone. And if more than anything, the one thing that the lesson that I take away more than anything from writing my PhD is that it's okay to change as you're writing. I think when I think about my original PhD proposal and what I have now, I think I needed 2 different PhD proposals for the research that I presented, and that's okay. I think what helped was discussing that with my supervisor and with colleagues and kind of speaking through it over and over again to reach the point now where I feel really comfortable and really confident with the research that I've done. Because I think in the beginning, when you're first researching things, you don't really see the golden thread that you want your thesis to go along. You have a general idea and you have, a general direction that you want to go in, or maybe several directions that you want to go in. And so the research kind of takes those different perspectives. But as you begin to research and as you go further into doing your interviews even, and as you engage with some other academics, with your supervisor a lot more, then you'll begin to see that there's maybe one specific direction that you want to go in. Once you identify that one direction, the research becomes a little bit easier, because when you narrow down and you pick your niche in your thesis, so to say, the research becomes more manageable. You'll start to realize that maybe the literature load is a little bit more niche and more nuanced. So you start to find literature that is, like Carlotta said, more specific to answer your research questions. So not just the generalized research anymore. So as you write and rewrite and change and adapt, that's something that you should take into consideration. Additionally, the thing that I think I made the mistake of doing is I waited until my final year to start writing. And that was a mistake that I think a lot of people, I don't think I'm alone in making that mistake. A lot of us make that mistake. And then we're in the final few months and we feel this extensive pressure that we need to start writing. I really wish I had started in the beginning with just 100 words a day, or, maybe 500 words a week. And if you don't end up using that, you don't end up using that, and it's okay. But writing down your thoughts and seeing the structure that you want to employ is a really good idea to kind of get your writing together and to start at some point. Because I think, especially when you're taking on a task of writing a thesis, it seems that there's so many things that you can write about, and there are. So when you start writing a little bit about this, or a summary of this article, or an overview of this research topic, that really does add value to your thesis in the end. And when you have like the final issue of only just putting together all of your different pieces of writing, it's a lot easier than writing everything from scratch. So yeah, those are just my 2 experiences that, yeah, I'd really like to share. But if we don't have, Eric has posted in the chat, he said, Indigenous women have a particular role in the intergenerational preservation of the traditional knowledge systems of Indigenous peoples. My concern is in the sense of whether this aspect is included in the intersectionality approaches to research. Thank you, Letitia. If I can add one comment to Eric's question and his later comments. Eric, are you referring to specifically, just to dumb down the topic a little bit more, there's been a new approach to trademark nature-based solutions from Indigenous communities. So for example, to allow for the protection of that knowledge to the Indigenous community from whence it's coming, to ensure that not everybody is just accessing this information and using it without referencing and acknowledging the community from whence it came. So firstly, I just wanted to know, is that specifically what you mean when you are referring to the guardianship of traditional ecological knowledge systems by Indigenous women. And secondly, if that's what you mean, this becomes a very difficult process because, especially with nature-based solutions and solutions from Indigenous community and Indigenous women in particular, that knowledge has been passed down from generation to generation. And more often than not, the knowledge that the traditional knowledge systems that are shared are community kept, if that makes sense. So finding a way to protect that information strictly within the confines of the law has been challenging in the past, because more often than not, it's difficult to associate that knowledge with one particular group of women, one particular knowledge system within the general Indigenous community, or within that specific woman's more internal communal base. So that is a recent development in the protection of nature-based solutions and Indigenous knowledge, but that is something that is to be developed soon, and hopefully someone will be doing a PhD thesis on it, and we can discuss that in more detail at this workshop. I think that is everything for today. Letizia, I don't know if you have any other comments or anything else that you want to add in, or yeah, if there's anything else that anybody else wants to add or say or comment.
No, I would just like to thank you both for the discussions we had, and thank you for the insights very much. And thank you all for listening to now.
Thank you so much for presenting, Letizia, and thank you, Carlotta, for co-presenting the session with me, and thank you for the comments and the insights that you've given. To all of the other PhD candidates that are present for this discussion, we will be going into detail like this for everyone's PhD presentations to provide you with some opportunity and some insight. And this is kind of the structure that we wanted to have it in. So we wanted to have more of an engaged discussion where we can talk through different things that you're dealing with or different research questions that you have. Again, you can present an overview of your entire thesis, or you can present us with a particular question that you're, a research question that you're more focused on, and we can discuss it like that. In the closing of today's session, I would like to thank the speakers. I know none of the speakers are still present with us today, but in their absence, I'd like to thank them for their presentations. And I'd like to thank Letizia for her presentation and for taking the time to share your research with us. It's not easy to share our research sometimes because it is kind of considered like our prized possession, and we always want to share it when it's at its final perfect stages. So thank you for trusting us and for engaging with us and sharing your research with us. We hope that those of you that are present today will be able to join us for the next session of the PhD workshop, which is tomorrow, 12 to 5 p.m. CET, so Central European Time. The session is called National and International Climate Litigation, Individuals, States, Companies, and Nature. So we will be continuing the workshop via Zoom. So the link that you utilized to access today's session will be also open for you to utilize for tomorrow's session. So thank you once again for joining us and for taking the time. It's been lovely to discuss with you and to share this opportunity with everyone. Have a great day or a great night further, wherever you are in the world, and we hope to see you again tomorrow. Thank you.
Thank you so much, everyone. Bye.
Bye.